ABCD testing, ABCD testing, ABCD testing, English testing, ABCD testing, ABCD channel ABCD testing, English testing, English testing, ABCD 1 2 3 4 1 2 3 4 5.
Hello， 1 2 係呢個黐埋，係。哇！好，呢個
Hello, everyone. So welcome back for part 2 of the second session of our conference today, which will be a discussion on the use of emerging technology in dispute resolution. So for those of you who have just joined us, we will have a panel discussion right now and also a Q&A session at the end of the session. So if you have any questions, feel free to write down your questions on the question slip available on your table and pass it on to our staff. And for those of you who are joining us online, you may enter your questions into the chat box as well. So now I would like to welcome our moderator and also our speakers for this session. So may I introduce to you our moderator for this session, Mr. Paul Starr, partner of King & Wood Mallesons, along with our 4 speakers, Ms. Liz Elm, Mr. Takashi Takashima, Mr. Michael Dennis, and also Ms. Puki Emmanuel. Let's give them a round of applause. Over to you, Mr. Starr.
Morning and good evening, ladies and gentlemen. Thank you very much for joining us. It's lovely to see a live audience here in Hong Kong, and no doubt millions of you worldwide tuning in to watch. Thank you. The year, ladies and gentlemen, is 2030, 2030. Donald Trump has invaded the White House and is refusing to leave. China wins the Soccer World Cup. 1 Hong Kong dollar buys you 1 British pound. William Shatner, now 100 years old, does the inaugural GBA space shuttle from Shenzhen to Shanghai in 7 minutes flat. And COVID is well and truly over. The last infection was in December 2021. So what about we international arbitration practitioners and arbitrators? Have we regained our diamond status on Cathay Pacific? Or are we still doing Zoom, WebEx, and Microsoft Teams hearings? What about technology? What is emerging now that will help us continue with our disputes and solve our disputes throughout the next 10 years? What can we expect to see? Well, here to assist us in that question are 4 of the world's most ably qualified practitioners in that field, and I will introduce them one by one as they speak, very briefly, and their full details are, of course, in the seminar link. They have suggested that you might like to ask them questions as they go along at the end of each of their presentations, and we'll certainly do that if there's time, but otherwise we'll try and do a Q&A at the end of the presentation as well. So I hope she's there. I can't see her, but no doubt she is there. Ms. Lisa Alm, our first speaker on a line from Sweden. She is the head of business development at the Arbitration Institute of the Stockholm Chamber of Commerce. She focuses particularly on innovation, product development, and communication. She's part of the UNCITRAL expert group on emerging technologies and the digital economy. And she's co-founder and/or chairperson of 3 dynamic companies, which seem, at least to me, to have technology at their heart. So, Lisa, I can see you now, and I understand you're very kindly going to give what I would call a cradle-to-grave presentation on how we use emerging technology in dispute resolution, or as you put it to me, a bird's-eye view. So over to you, Lisa.
Thank you, Paul, and hi, everyone. I am really excited to be here. I would have been even more excited to actually be there in Hong Kong with you today, but I'm coming now from Stockholm, where it's still early morning. So as Paul mentioned, I am Lisa Alm, and I am Head of Business Development at the Arbitration Institute of the Stockholm Chamber of Commerce. It's a bit of a mouthful. I'm a lawyer, but I've spent most of my time in tech, and I'm really excited about the intersection of law and technology. And I will spend the next 14 minutes or so talking about 2 things. It's an overview of the tech used in dispute resolution and a little short discussion of what the challenges that may lead to. I'm going to stay fairly high, as Paul mentioned, and I'm going to try to avoid jumping into the technology too much, even though I'm really keen to. So you all will be familiar with the basic phases of a dispute. You need to prepare and manage your dispute. Hopefully you get to resolve it, and then you need to enforce the result somehow. In all stages of the process, starting long before we even get to the dispute phases, there are various automation tech projects going on. I mean, if you look at the journey of 2 parties meeting, contracting, fighting, and hopefully becoming friends again, I would imagine that the only step humans will remain truly superior in over time is the fighting step. The rest will hopefully enhance with technology one way or the other. So let's take a look at how we can enhance them. So if we look first at managing and preparing, if we're looking at how we can simplify the process of preparing the sorry, here we've come a fair way when it comes to available solutions. Although I would say actual adoption of them might be lagging behind some. But when it comes to preparing your case, we've got, for instance, advanced data analysis to help you find parties to a class action. You can also have analyze the rulings across different judges or forums in order to establish the best place to file your lawsuit in. And you also have predictive analysis using fairly simple technology to predict time and cost of a case. And then you have more advanced technology like AI to predict the outcome of a case. And then, of course, various arbitrator databases to help you find and evaluate arbitrators. And then you get a plethora of systems helping you to also manage the dispute, like online case management platforms, like the SEC platform that has been my baby over the last couple of years. You've got e-bundle solutions, and not to forget the star of last year, the virtual hearing. When it comes to technology for hearings, I would imagine and I would hope that the next step of enhancing that would be the increased use of drones to replace site visits, or using virtual reality to illustrate complex procedures and historic sites. So these tools are generally try to make the process more efficient. They cut out some hopefully redundant corners in an otherwise quite classic dispute process. Some of these methods may raise concern, but in the larger scheme, they are less complex than the next category, which is solutions targeting how we resolve a dispute. And here you got various solutions helping you to either settle the case or helping you to solve it, to adjudicate it. So I'm well aware that some of the terms on this slide look like I randomly string them together from some sort of startup buzzword bingo. So let me briefly walk you through them. So the first one here, escalation solutions using logics and a guided process. So this is essentially a chatbot asking you to submit relevant information about your claim to help you understand if you've got a case or not, while at the same time helping you navigate towards a settlement with the other party, narrowing down the issues to the core legal matter and helping you find common ground with the counterparty. It's often found in smaller, repetitive cases like consumer disputes between buyers and sellers on, say, eBay. And then you got various blind bidding processes. This is essentially a platform helping you find the neutral ground with your counterparty. And both of these types of solutions are sometimes coupled with automated or templated settlement agreements. So these solutions are mainly trying to get the parties to agree amicably, that's a tricky word. But then you've got the solutions targeting adjudication of the dispute one way or the other. Most of you will think of predictive AI solutions. Essentially, this is when you ask an AI to actually rule on the case. This is already being used in quite a few places, especially in national courts, even if we're generally, again, talking smaller, repetitive cases where the courts are using them as a way to battle backlogs. So this brings us to decentralized justice, or game theory-based crowdsourced non-expert solutions. And here, if you didn't get your bingo on your buzzword, this was probably when you should have hit it. The poster child for this is a company called Clearos, an American startup, which some of you may have heard of. They are often referred to as an example of blockchain arbitration, but the more interesting aspect of them is, to me at least, not that they use blockchain for certain aspects, but how they adjudicate the dispute. So they crowdsource a number of arbitrators for each case from a pool of often non-lawyers, and then they tie the payment to the arbitrator to whether he or she got close to the popular result. I.e., if you vote like others, you get paid more than if you dissent. So these solutions are really exciting from a tech perspective, but they also give rise to more complex questions from a legal perspective than the ones used for preparing and managing the cases. When it comes instead to enforcement, the development doesn't seem to have come quite as far yet, but the most obvious trend to keep an eye on here is blockchain awards, or different automated awards. A blockchain-based award could, for instance, be used to automatically enforce an award similarly to a smart contract being used to automatically carry out a transfer. It will also be exciting to see what the Singapore Convention might open up to in terms of different new solutions leading to some sort of an enforceable result. So this was a 90-minute, mile-a-minute run-through of some of the type of technology and solutions that we're seeing and that we will be seeing more of. And as you might have guessed, I'm a tech optimist and really excited about what we can do with these solutions. I also think that we need tech to fix some of the issues that we have in the judicial world today. However, I do see that they come with some concerns. So for us to be able to make the most of them, we must make sure that we mitigate those concerns as best we can. And as I see it, a broad rollout of technology in the judicial system presents challenges relating to three aspects: the underlying technology, the access to the technology, and legislation and legacy. Starting then with technology, some of the issues with tech is quite well discussed. When it comes to AI, for instance, accessing the data that you need to train the AI solution is not easy. When you do access it, it generally contains human bias, which we don't want the machines to replicate. And in addition to this, some of the ways that the more powerful AI solution work means that we often get a result without knowing exactly how it reached that result. We lack the transparency and predictability that we require in a judicial system. When it comes to blockchain, there are several issues relating to how blockchain work when it comes to, for instance, knowing who you're dealing with and who you can hold accountable for what. So this is something being addressed quite regularly in debate and by UNCITRAL and other international organizations. But another issue that I see less discussion around, at least within, well, my own little filter bubble, is the discussion of access to justice. I see different areas where access is and will become an issue. First, access to technology might be the new access to justice, in that sophisticated technology might be increasingly necessary to claim your right, to even get your day in court. Tech is often mentioned as the solution to access to justice issue, in that it will make it so much more efficient, remove all the backlogs and so forth. But it also risks create a barrier for those that have less technology resources. Even just an unbalanced distribution of this technology might lead to an inequality of arms between our parties. Imagine today if you were going up against a counterparty using smartphones and computers, and you could only use a goose pen and a fax machine. That wouldn't be very equal. Thirdly, market forces and access to data generally leads to technology being developed for larger jurisdictions and languages. Coming from Sweden and speaking the widely popular language of Swedish, this issue hits particularly close to home. Lastly, there are challenges with legislation, and I think more importantly with legacy. Some legislation might need updating both to promote and restrict the use of technology. Some of the built-in safeguards in current legislation, today's various checks and balances, might be rendered less efficient if the threats are coming from machines instead of from humans. Also, if we can automatically enforce an award using smart awards, that would undermine the need to adhere to the checks and balances provided by, for instance, the New York Convention. And when it comes to legacy, arbitration was created to be flexible, and I think at its core, it might actually stand the test of both time and technology fairly well. However, best practices and habits that have been built up over time might be too confining to allow for the changes that we want to see. And anyone who's ever made a New Year's resolution to start exercising knows that habits can be even harder to change than legislation. So where does that leave us? What can we do? What is the role of international community and policymakers, many of whom I guess are in here today? Well, it seems natural that we need to find a way to both promote the use of technology for so many reasons, while at the same time make sure that we protect the core legal principles. We need to be the promoters of technology and the guardians of the rule of law at the same time. And yes, I may have watched one or too many superhero movies. And yes, I may or may not wish that I had an actual cape in my closet as opposed to a word processing program as my main tool. But this is our chance to save the day, to take on the fight of making sure that we take advantage of advanced technology to fix the world, while making sure that we protect it from the potential harms of the same technology. Unfortunately, there's a lot of guardians out there and there's a lot of work being done. So you will hear more from it from some of my fellow Guardians of the Galaxy on the panel in just a few moments. So with that, I say thank you.
Thank you very much, Lisa, and thank you for including that animation of me in the middle on that photo there. Sticking with the theme, Lisa, of Guardians of the Galaxy, or Guardians of the Justice, I suppose I would say, you described a system, a proprietary system, where non-lawyers are asked to vote in the delivery of justice, and they release payment according to majority vote. But if we're true guardians of justice, do you envisage situations where that type of informal justice by people who know nothing about arbitration practice can go wrong?
Well, that sounds almost like a leading question you got there, Paul. Yes, naturally, this can go wrong, just as it can go wrong in court. However, maybe for different reasons. In Kleros, the cases are not necessarily ruled on their legal merits, but rather on ex equo e bono, essentially on what's fair and right. There are some procedural rules in there as well, but overall it's based on fairness. And hopefully every now and then that will coincide with what the laws say, otherwise we may need to review our laws. But similarly, as in court, you can appeal a case in Kleros, so then the process is then redone, but with more arbitrators. The idea is that the more arbitrators you get in there, the more likely it is that the outcome is going to be something that is not completely off the grounds. So what you essentially need to see Kleros' outcome is rather an assisted settlement agreement than an award. They are, for instance, not enforceable under the New York Convention. The first Kleros settlement to be tried in court was actually tried in a Mexican first instance court just recently, and was upheld on contractual basis. So when you look at a Kleros outcome going right or wrong, rather compare it with an assisted settlement tools like mediation or blind bidding or, well, flipping a coin. As long as the parties agree to the method, it gets the job done. And I think it can be a great settlement tool, but key to getting it right will be that the parties know what they're buying into. So yeah, I think it can go both right and wrong, but as long as the parties know what they're buying, I think it's mainly right.
Food for thought. Thank you very much. And we'll return to some discussion about that later. Let me introduce you to our second guardian of the galaxy then. I saw him on the screen a moment ago, Mr. Takashi Takashima. Takashi is Senior Attorney of the Litigation Bureau and the Minister's Secretariat International Affairs Division of Japan's Ministry of Justice. He has a special focus on UNCITRAL and ICSID, is a former judge and a former diplomat, and has had personal involvement in UNCITRAL's project on stock-taking of developments in DR in the digital economy, often called the Stock-Taking Project. And Takashi, I think you're going to present on stock-taking of developments in dispute resolution in the digital economy. Over to you.
Thank you, Paul. Greetings to everyone from Tokyo. And thank you again, Paul, for the introduction. And I thank the organizers for this opportunity to speak. My presentation will focus on UNCITRAL's project on the stock taking of developments and dispute resolution in the digital economy. Please note that I may refer to the phrase dispute resolution in the digital economy and its acronym DRDE. Next slide, please. So we will first take a quick look at the history of this project. During UNCITRAL's session in 2020, Japan put forward a proposal that the Secretariat be vested with the mandate to conduct relevant activities to monitor the changing landscape of international dispute resolution. In the Commission, general support was expressed for the Secretariat to conduct research and take stock of the wide range of recent developments, and the Commission requested the Secretariat to explore possible means to implement such activities. Thereafter, a series of online workshops on DRDE were co-organized by the Ministry of Justice of Japan and UNCITRAL in the lead up to the commission session held this year, late June to mid-July. The first was a kickoff discussion in February, and the second was an extensive workshop held for 2 consecutive days at the end of March, in which Lise, the previous speaker, also contributed, and thanks to Lise on that occasion. Based on the findings of the online workshops, which crystallized into a note prepared by the Secretariat during session this year, UNCITRAL considered and approved the implementation of the stock-taking project, through which the Secretariat will compile, analyze, and share relevant information regarding developments in dispute resolution in the digital economy. So next slide, please. So why did Japan put forward this proposal? There are 4 key points worth mentioning about our initial thoughts. Number 1 is that even before the pandemic, digitalization had been a long and gradual trend in various aspects of international trade, including dispute resolution. With or without the pandemic, this exercise was needed at a certain stage. Number 2 is that, yes, we were prompted by the pandemic to think further about digitalization. The pandemic made us reaffirm the need to improve resilience toward global crises and to achieve modernization. As we have seen from the onset, it seems undebatable that the pandemic has played a role in accelerating digitalization. Number 3 is that in the field of international trade, dispute resolution deserves special attention because it is the cornerstone in bringing justice, in other words, materializing legitimate claims and rights. Finally, and on the way forward, what we came up with was the idea to monitor the changing landscape of dispute resolution, the evolving practices, and the development of new forms of dispute resolution. Next slide, please. Recognizing that there is a need to take stock of developments in dispute resolution, the next step would obviously be to define the scope of the stock-taking project. And in doing so, as I briefly already touched on, we started with a kickoff discussion, which made a perfect segue into the workshop in March this year. As the discussions at the March workshop provided wealth of information which contributed to defining the scope, I wish to give a brief overview of some of the salient points that were made. Starting the discussions, it was mentioned that arbitral tribunals were vested with broad discretion to use technological means under the UNCITRAL rules. Reference was made to the decision by Working Group 2 to include a specific provision on the use of technological means in the draft UNCITRAL expedited arbitration rules. It was still at the time at a drafting stage, which aimed to clarify the discretion of the arbitral tribunal with regard to the use of such means. Discussions on these points confirm the legal basis of the use of technological means in proceedings and rationalize the need for an extensive assessment of its impact. Discussions also focused on the increased automation and digitalization in arbitration. It was mentioned that automation was being increasingly employed by the parties and their legal counsel in preparing submissions and evidence, by the institutions in administering cases, and by the arbitral tribunal in conducting the proceedings and rendering their award. It was also mentioned that while the benefits of automation could be vast, interoperability of the systems as well as confidentiality requirements could pose some difficulties. Reference was also made to the digitalization of documents. In the same vein, specific reference was made to the use of technology for the selection and appointment of arbitrators. It was also illustrated as benefiting the parties in the most time-consuming stage of arbitration. At the same time, it was stated that such a technology required collection of data from a wide range of sources, which posed certain challenges. On online and remote hearings, it was stressed that there was a need for common guidance on their conduct based on the wide range of existing guidelines and protocols prepared by arbitral institutions and others. An aspect that obtained great attention was the conduct of witness examinations in online and remote hearings. For example, it was mentioned that there was still skepticism about creditworthiness of the testimony and the lack of immediate contact between the tribunal and witnesses. In response to such concerns, it was stated that the increased use of written witness statements with hearings, allowing arbitral tribunals to actively engage the witness and providing for cross-examination, may serve as a possible solution. In light of these discussions, suggestions were made for work on providing guidance on witness examination and remote hearings, taking into account the different approaches in different jurisdictions. With respect to the discussions which focused on ways to ensure due process and fairness, one of the aspects highlighted was the importance of consultations between the arbitral tribunal and the parties, often referred to as the case management conferences. It was mentioned that during a case management conference, a number of issues on the conduct of the proceedings were discussed and a procedural timetable is prepared, creating a basis for common understanding among the parties and the arbitral tribunal. It was stressed that this had a positive impact on increasing the efficiency of the proceedings as well as the predictability for the parties, thus enhancing fairness. In this context, reference was made to the draft provision on consultation and the draft UNCITRAL expedited arbitration rules, as well as the proposed provisions on case management conference and the ICSID convention arbitration rules, which provided that the identification of contested and uncontested facts and of clarification of the issues in dispute as being amongst the objectives of holding such conference. With respect to the use of technology in international mediation, it was reported that online mediation had resulted in a similar and in some cases a higher settlement rate than that conducted offline. Benefits of online mediation, particularly for MSMEs, were also emphasized. It was pointed out that efforts could be made to address problems that arose in online mediation, mostly due to technical difficulties and environment distractions. It was stressed that preserving procedural fairness was key in online mediation, and calls were made to ensure equal treatment of the parties, taking into account any imbalance in technological competency, maintain the neutrality of the mediator so as to build trust, provide for consistent and predictable proceeding, and finally impose ethical standards. Next slide, please. Based on these fruitful discussions at the March workshop, the initial key findings were that the scope of the stock-taking project may include compilation of technology utilized in dispute resolution, as well as related statistics, comparative analysis of legislative responses in case law, identification of areas where a harmonized legal approach would be useful, compilation of information and analysis on the possible impact of the use of technology on due process and fair conduct of the proceedings, and ways to preserve the core principles of party autonomy and flexibility, compilation of information and analysis on the obstacles to remote arbitration and mediation proceedings and means to overcome them. Next slide, please. The outcome of the discussions and the key findings were presented to the UNCITRAL and were considered at its most recent session. As a result of deliberation, UNCITRAL approved the stock-taking project and acknowledged that it was widely felt that the stock-taking would need to take into account the disruptive aspects of digitalization, in particular with respect to due process and fairness. This acknowledgement by the Commission provides guidance in terms of the implementation of the project. It is also noteworthy that focusing on the disruptive aspects of digitalization is squarely in line with the rationale of stock-taking contemplated at the outset, which included, among other things, the need to improve resilience towards global crises. Digitalization is set to bring impacts both positive and negative. Simply pursuing digitalization and dispute resolution risks undermining the core values and principles of dispute resolution and running counter from improving resilience. Thus, increasing the use of technological means to improve resilience requires at the same time addressing its drawbacks. Next slide, please. Following discussions at UNCITRAL's latest session, proposed topics under consideration as specific topics for the stock-taking project include the following: disruptive impact of digitalization on due process and fairness in arbitration, rules, protocols, and practices pertaining to online witness examination, and evolving practices regarding online mediation. Let me provide an overview of these topics. First, speaking of disruptive impact of digitalization on due process and fairness, it has been mentioned for quite some time that the massive volume of information in dispute resolution, including arbitration, poses a serious concern on due process and fairness. In making a determination on disputed issues in some complex cases, dealing with large quantities of information may purely be unavoidable, but it does not seem that the same applies across the board. As arbitrators are human beings alone in carefully examining and assessing the documents before them, large volumes of unnecessary information risks distracting the arbitrator's attention from the real issue at dispute and essential information. The flood of information creates a serious risk that the key issues at dispute are covered and arguments and evidence submitted by the parties are overlooked or not fully digested by the arbitrators, and puts the award at risk of not being able to give proper reasons. This in turn means that from the viewpoint of the parties, they are also at risk of being deprived of their right to be heard and due process. This problem, which is at times called the flood of information problem, is not necessarily new. It was present already when documents were completely paper-based. Copy machines were good enough to create this issue. It cannot be overstated, however, that this problem is aggravated when proceedings are digitalized. Concept of digitalized dispute resolution proceedings, the need to address the flood of information problem is especially pressing. So the question is, how best can this issue be addressed? To give more clarity in terms of what research activities should be conducted by the stock-taking project, it is expected that a specific list of issues, including those pertaining to the use of case management conferences, will be fleshed out. Second, on witness examination, those conducted in virtual format, bringing in issues which do not exist when conducted in the traditional in-person format. For example, without the presence of the arbitral tribunal and the parties, there is a risk that coaching of witnesses may occur while they are actually testifying. In this regard, there already seems to be abundant experience in practice in the form of rules, protocols, guidance, and also in specific cases, which will enable in-breadth research on how the use of technology has been incorporated and what measures have been taken to address the accompanying concerns. Third, on online mediation, this is an emerging area that deserves particular attention. It has been referred to by practitioners that a significant increase in the use of online mediation has been seen since the outbreak of the pandemic. For online mediation to stay, it would be important to think about how proceedings may be conducted online in a way that ensures the use of technology to be an advantage, consistent with legal frameworks and not a distraction. To conduct stock-taking activities on witness examination and online mediation, a detailed list of issues on those topics will also be needed. Next slide, please. Finally, and on the next steps, as discussed to implement the stock-taking project, the specifics need to be discussed further. In this connection, I just would like to do a bit of promoting. The Ministry of Justice of Japan will be holding the 2021 Tokyo Forum on Dispute Resolution on 7 and 8 December, in about a month from now, and expects that it will provide an opportunity for further discussion on stock taking. Details of the event will be shared through various channels in due course. Furthermore, the Secretariat of UNCITRAL will be organizing a colloquium during 28 March to 1st of April next year, in which the stock taking project is one of the key topics to be discussed at that occasion. And Paul, this brings me to the end of my presentation, and back to you.
Thank you very much, Takashi. Let's hope that we can all be there in person next year. We are, Takashi, as you know, in the year 2030. And my question for you is, if you look into your crystal ball, what's your expected outcome of the UNCITRAL stock-taking project?
Yes, and thanks, Paul, for the question. And indeed, that is a very relevant question. It is expected that through the implementation of the stock-taking project, information, as I mentioned in my presentation, will be compiled, analyzed, and shared, and especially for the topics which I referred to in my presentation, ways to address the issue of excessive information, online witness examination, and online mediation. We expect that the result may lay the groundwork for future work in UNCITRAL. Thanks, Paul.
Thank you very much. We'll return to that, I'm sure, in the Q&A. And so let's come now to our pre-recording of Mr. Michael Dennis. Mr. Michael Dennis has recorded his presentation because otherwise it would have been 3 a.m. for him. He's Senior Legal Advisor with the Kosolchik National Law Center. His APEC and UNCITRAL credentials are formidable, particularly in the field of ODR, and his presentation is indeed entitled ODR in the Digital Economy, Past, Present, and Future.
Good afternoon, everyone. It's a privilege to be part of such a distinguished panel. I'd like to thank the Secretary for Justice, Teresa Chang, James Ding, and Michelle Fung for inviting me to speak. Do you ever use your smartphone to answer your questions? For example, Siri, will it rain today? Google, how do I get home? Imagine that you're having a dispute with a business. You ask Siri, what do you think a fair resolution of the dispute would be? And Siri would search through millions of cases, crunch a lot of numbers and say, a fair resolution would be this. The field of online dispute resolution, or ODR, uses technology in a similar fashion to enable parties to solve their disputes remotely without having to travel to the venue where the dispute has taken place or where it's being decided. The future of ODR will include greater use of algorithmic resolution of cases. Online dispute resolution has a wide definition covering almost any dispute resolution process, including negotiation, mediation, facilitation, arbitration, or other adjudication, so long as it's carried out online. ODR might be defined as ADR enhanced by technology. UNCITRAL recognizes that ODR is a vital way of resolving disputes by using technology as a facilitator to traditional methods such as negotiation, mediation, and arbitration. UNCITRAL therefore wrote the technical notes on ODR to establish basic procedural recommendations or good practices for ODR. UNCITRAL drew on the success of existing ODR systems, such as those developed by eBay and PayPal, with combined experience resolving 60 million cases a year. According to the UNCITRAL technical notes, ODR is designed to assist buyers and sellers in resolving disputes in a simple, fast, flexible, and secure manner without the need for physical presence at a meeting or hearing. For most e-commerce disputes, ODR is just not an alternative, it's the only practical redress option. The pandemic has greatly accelerated the use of ODR. The computer-led process is fast, cheap, and user-friendly. It reduces timelines and costs to keep them in proportion with the value of the underlying transaction. And it offers participants the flexibility to engage in the process at the time and the place that best suits their needs. ODR requires a technology-based intermediary, the ODR platform, as the framework that allows the parties to resolve the dispute electronically. All communications in ODR proceedings should take place via the ODR platform. The use of technology enables parties to communicate without the intervention of a neutral person. It offers seamless navigation through a myriad of dispute resolution options. The ODR platform and ODR administrator are responsible for process issues, including fairness, due process, transparency, accountability, neutral appointment and selection, and the performance capabilities of the ODR platform. And the platform must be highly secure. The General Assembly has endorsed the UNCITRAL ODR technical notes, recommending that all states and other stakeholders use the technical notes in designing and implementing online dispute resolution systems for cross-border commercial transactions, and requesting all states to support the promotion and use of the technical notes. The resolution represents the views of all 193 members of the UN General Assembly. ODR should follow a rule-based approach to ensure that the parties are afforded the same standard of due process, regardless of where they are located. APEC is the first region to implement the work of UNCITRAL on ODR. It created the Apec Odr Collaborative Framework, which draws from the UNCITRAL technical notes. And under paragraph 1.2, the Apec Odr Framework is described as a framework for business, particularly MSMEs and participating economies, providing ODR through negotiation, mediation, and arbitration for B2B claims. Of course, negotiation, mediation, and arbitration are traditional dispute resolution mechanisms. But the Apec ODR framework expects the use of technology, including AI, to automate them. Multiple proprietary ODR systems are available in a very limited fashion in Apec. The collaborative framework allows them to spread the use of ODR across the Apec region. One such provider is EBRAM, and you will hear from Emmanuel about their platform today. The collaborative framework includes a set of model ODR procedural rules. And under paragraph 2.2 of the framework, ODR providers partnering with Apec agree to abide by the procedure rules. The Apec procedure rules are based upon two UNCITRAL texts. The UNCITRAL arbitration rules provide a comprehensive and internationally accepted set of procedure rules which the parties may agree to for their arbitral proceedings. The Apec model procedure rules apply by agreement of the parties. The appendix to the Apec rules also contain a model ODR clause for contracts for the parties to agree to use ODR. The procedure rules exclude business-to-consumer transactions for several reasons. First, the amounts at dispute in those cases are typically very small and outcomes are difficult to enforce cross-border. Second, the vast majority of e-commerce disputes involve B2B. UNCITRAL has estimated that worldwide e-commerce for B2B was worth some $21.8 trillion in 2019, while B2C e-commerce was worth only $4.9 trillion. And third, most private international law instruments exclude consumers. Article 3 of the rules deals with communications. In order for ODR to work, a common technological platform must be used by all the parties to resolve the dispute electronically. All communications should therefore take place via the ODR platform. Section 3 of the framework deals with the different stages of the dispute resolution process. It's based on sections 7, 8, and 9 of the UNCITRAL ODR technical notes. Both the collaborative framework and procedure rule call for the use of negotiation, mediation, and arbitration. The various stages act as a funnel so that only a few cases need to escalate to an online arbitrator. Indeed, most disputes can be resolved by negotiation or mediation. With ODR, the negotiation phase is managed entirely by software for speed, efficiency, and cost effectiveness. If no settlement can be found, the case may escalate to third-party resolution. The ODR provider selects the online neutral from a list of approved neutrals. The neutral provides online mediation and, if required, online arbitration. There are no binding commitments, but economies that opt into the collaborative framework allow their ODR providers to participate in the framework. To date, China, Hong Kong, China, Japan, Singapore, and the US have opted in. Other economies are actively pursuing opting in. Apec then partners with ODR providers in offering ODR for business-to-business disputes involving MSMEs. Under paragraph 4.2 of the framework, each ODR provider will provide its own ODR platform for resolution of disputes under the ODR framework. Partnering ODR providers must agree to follow the procedure rules and to charge fees proportionate with the amount in dispute. The Apec Economic Committee oversees ODR providers with help from leading academic institutions. If an ODR provider is not in compliance with the rules, the Economic Committee may remove the ODR provider from its list. Participating ODR providers are listed on the Apec website with a disclaimer of what businesses should know before they select a provider. Apec has a crucial role to play in promoting ODR to MSMEs, governments, and the legal community. The collaborative framework asked Apec economies to encourage their businesses, especially MSMEs, to use the ODR providers. Apec has also given academic the institutions a key role in assisting with MSME capacity building. Surveys have shown that microenterprises tend to work without clear contracts and dispute resolution clauses, which leaves them vulnerable in case of a dispute. Widespread adoption of ODR would promote a culture of contract. In turn, it would make transactions more efficient, driving down risk and making MSMEs more competitive by lowering cost. ODR can bring economic advantages for everyone, reducing transaction costs for both sellers and buyers in the supply chain. For ODR to be effective, the relevant rules, procedures, and the enforcement of online arbitration awards must be harmonized between economies. For member economies, this means adopting or implementing the relevant private international law instruments. This has been a key component of the Apec EC-CELI legal group work. And here you see a listing of the major instruments. All Apec economies have implemented the New York Convention. 18 out of 21 economies have implemented the UNCITRAL model law on international commercial arbitration. And additionally, all Apec economies recognize the validity of agreements concluded electronically, which is the subject matter of the model law on e-commerce and the Convention on the Use of Electronic Communications in International Contracts. Another key instrument for ODR is the Singapore Convention on Mediation, which just came into force in September 2020. It's been ratified by Singapore and signed by the US and China. The next step is for more economies to opt into the framework to allow more providers to become partners and more businesses to access ODR. Again, there are no binding commitments for economies. And you can find out more information about the collaborative framework on the Apec ODR website shown here. The Apec EC is also monitoring modern technologies as it relates to ODR. Artificial intelligence, or AI, can be used to power the various components of ODR, such as handling multiple languages, guided dispute resolution, evaluation of cases, computer-aided mediation, or AI-only mediation. AI can greatly simplify, accelerate, and even out the dispute resolution process. Best of all, AI is continuously improving as it gains additional data. As a logical extension of the use of AI, an interesting possibility is the development of robot judges. Already, Estonia is developing the first robot judge that would use algorithms to adjudicate small claim disputes under 7,000 euros. Estonian government officials hope the system will help clear a backlog of cases for judges and court clerks. The main use of algorithmic judges at present is to answer relatively simple questions that require a search through large quantities of data. For example, in China, robots are used in some courts to retrieve case histories and past decisions. The reason for the more limited use has been that AI algorithms are not yet good at making sense of unstructured data. Blockchain technology uses cryptology and decentralized distributed ledger to record a transaction across many computers, ensuring that data cannot be altered. In blockchain-based smart contracts, the software code controls the execution of the agreed terms, and transactions are trackable and irreversible. ODR can be used to resolve disputes arising out of smart contracts, and smart contract can also be used to enforce ODR decision awards. Technology is not only changing society, but also the way we resolve disputes. With the help of technology, ODR opens up access to justice to ordinary people and MSMEs. Since the COVID-19 pandemic, our ability to travel and hold in-person meetings has been limited, suddenly making ODR a necessity and a mainstream feature of ADR. Today, ODR goes beyond online ADR, making use of advanced facilitative technologies and adjudicative algorithms. We have only begun to tap into the potential of computer-led processes to resolve disputes. With the advance of artificial intelligence, the legal profession may see more changes in the next 10 years than have taken place over the past centuries. Thank you very much.
Thank you, Mike. And that presentation does indeed segue beautifully into that to be given by Emmanuel Tar. Very nice to see you in person here, Emmanuel. Chief Executive Officer of Hong Kong's EBRAM International Online Dispute Resolution Centre Limited. Emmanuel was formerly counsel for the Secretariat of the International Court of Arbitration at the ICC's Asia office, and she previously worked as Deputy Counsel at the ICC in Paris. And as you can see, her topic will be harnessing law tech in the provision of dispute resolution services. Over to you, Emmanuel.
Thank you very much, Paul. My co-panelists have talked about new technologies that may be used to improve the efficiency of the dispute resolution process. You've also heard about ODR as a technology that may be adopted in the provision of dispute resolution services. Today and in the next 10-15 minutes, I am going to introduce an ODR platform that will integrate some of the new technologies. But before I do that, I'd like to give a brief overview of the dispute resolution landscape in Hong Kong and how law tech and ODR are being explored. Takeshi and Mike have walked us through the various initiatives of UNCITRAL and Apec. Recent initiatives have also been taken by the Hong Kong government to promote the use of modern technology in the provision of legal services. The Chief Executive 2018 Policy Address recognized the importance of developing law tech. Due to the COVID-19 pandemic, the Hong Kong government introduced in April 2020 the Law Tech Fund to assist small and medium-sized law firms and barristers' chambers in upgrading their IT systems. The COVID-19 ODR scheme has also been introduced to provide a speedy and cost-effective means for the general public and businesses in Hong Kong to resolve COVID-19 low-value disputes. And EBRAM Center has been engaged as the service provider for this scheme and has developed a COVID-19 ODR platform. The Hong Kong Department of Justice is exploring the development of a Hong Kong legal cloud to provide safe, secure, and affordable data storage services for the local legal and dispute resolution communities. In April 2021, Hong Kong, China opted into the Asia-Pacific Economic Cooperation Apec Odr Framework. As Mike has mentioned in his presentation, EBRAM is an ODR provider under the Apec Odr Framework. But before introducing EBRAM's ODR platform, let me say a few words about EBRAM and its services. EBRAM is a non-profit company established in 2018 in response to the government's call in the 2018 policy address and with the support of the Asian Academy of International Law, the Hong Kong Bar Association, and the Law Society of Hong Kong. EBRAM's vision is to offer a one-stop shop platform for commercial parties from all over the world by providing a deal-making, mediation, and arbitration online platform. EBRAM not only develops ODR platforms and provides ODR services, but it also administers cases like any other arbitral institutions and appoints neutrals from its panel of mediators and arbitrators when the parties are unable to agree on one. EBRAM has developed its own video conferencing and e-signing systems and provides technical support for hearings and law-related events. I will now give you a brief overview of the ODR platform developed by EBRAM. EBRAM launched the COVID-19 ODR platform in June 2020 following the introduction of the COVID-19 ODR scheme. And under that scheme, the platform is applicable to disputes arising out of or in relation to COVID-19, cases where the claim amount is less than 500,000 Hong Kong dollars, and cases where one of the parties to the dispute is a Hong Kong resident or a Hong Kong company. The platform takes the form of an interactive website with video conferencing system. It is available in traditional and simplified Chinese and English and adopts a three-stage proceeding: negotiation, mediation, and arbitration. Each stage of the proceedings will be completed within a short period of time. The ODR proceedings are governed by a set of procedural rules developed by EBRAM. Under this scheme, IBRAM has trained more than 150 mediators and arbitrators. They came from diverse backgrounds and different jurisdictions, including Hong Kong, the United Kingdom, Australia, India, and Singapore. Now moving to the Apec Odr Framework platform. IBRAM is an ODR provider under the Apec Odr Framework and is currently developing its Apec Odr platform to provide a mechanism for MSMEs in the Apec economies to resolve cross-border business-to-business disputes. IBRAM has launched its Apec rules, which comply with the Apec Odr framework and incorporate the Apec procedural model rules. The platform adopts a multi-tiered ODR process with a three-stage proceeding: negotiation, mediation, and arbitration, and is available to disputes under 500,000 Hong Kong dollars within the scope of the Apec framework. However, parties may choose to use the Apec rules for disputes involving more than 500,000 Hong Kong dollars. The Apec platform will commence operation towards the end of the year. Let me now share with you some of the main features of our Apec ODR framework. The ODR platform provides the parties and neutral with a convenient, secure, and efficient communication means for each stage of the proceedings. So from the filing of the notice to commence proceedings up to the settlement agreement or the rendering of the arbitral award, the parties and neutral will be required to exchange all communications and case submissions through the online platform. And to facilitate the submission of the request for commencement of proceedings, the claimant will be able to file its notice to commence proceedings by completing an online notice directly on the platform. The platform includes functions such as video conferencing system developed by IBRAM, a calendar for relevant dates and deadlines, and a board for the neutral to communicate with the parties. Meetings, case management conferences, and hearings can be arranged through the platform, and video conferencing is available during the process to maximize efficiency and to reduce cost. In terms of technology, the platform will include real-time transcription, e-bundle, e-signature. All documents exchanged to the platform will be saved on a highly secure cloud storage using blockchain technology. The platform is currently available in Chinese and English and will also be made available in other languages spoken in the Apec economies. As you can see, strong technical support in all aspects will be provided to users of the IBRAM's ODR platform. In addition to this, IBRAM will issue a note to parties and neutral to provide guidance on the process under the Apec rules and the use of the IBRAM Apec ODR platform. IBRAM has launched its mediation and arbitration rules in June 2021 and is currently developing a standalone mediation and standalone arbitration ODR platform to provide fast, convenient, and secure ODR services at a reasonable fee without restrictions in terms of the location where the dispute has arisen, the nationality of the disputing parties, the type of dispute involved, or the amount in dispute. Parties can opt for an online negotiation, e-mediation, or e-arbitration, or a combination of three modes. IBRAM has been working on other projects to enrich its law tech portfolio. IBRAM is currently looking into developing IBRAM's legal cloud portal to provide safe and affordable data storage services, as well as AI, machine learning translation, e-transcription, and e-bundling systems, which will be new features to add to its existing and future platforms. IBRAM will also adopt advanced technologies such as blockchain, real-time translation to provide a deal-making platform. And through IBRAM online deal-making platform, parties from different locations can efficiently negotiate a deal by conducting meetings and sharing documents on the platform and conclude their agreement digitally. Advanced technologies are going to transform the dispute resolution landscape. AI can create significant time and cost savings for dispute resolution. Applications such as chatbot, AI translation, e-transcription, The adoption of blockchain will lead to a significant shift in the way contracts are managed and parties interact with each other. It tracks down and records contractual events and generates a robust and reliable audit trail of past events, if and when a dispute arises. This will help narrow down the scope of disputes and avoid disputes and improve the efficiency of the dispute resolution process. The development of cloud services can provide highly secured storage for a large volume of legal documents and materials with advanced cybersecurity technologies, including certificates, biometric, token-based authentications. EBRAM is a forerunner in law tech and strives to be a key enabler for cross-border trade under the new normal through its services such as e-signing, ODR platform, and other law tech services. The Apec Odr platform is expected to be launched by the end of December, and EBRAM's legal cloud portal in the first quarter of 2022. To conclude, EBRAM will continue to integrate the latest technologies by the end, the latest technology to enhance its platform and systems. EBRAM welcomes feedbacks and comments from users and stakeholders to ensure that its services meet their expectations. And finally, as part of its ongoing efforts to promote ODR and law tech services, EBRAM will continue to engage in capacity building, raise awareness, and encourage the use of ODR. Thank you.
Well, thank you very much, Emmanuel. And a number of questions are coming in now, so thank you very much. Please keep your questions coming. One of the themes, Emmanuel, if I can ask you first, is on confidentiality and security and ODR. And the questioner asks, how does your particular organization try to ensure cybersecurity?
So cybersecurity and data privacy are top priority to ensure protection of all information and communications through our platform. EBRAM offers a reliable and secure platform, first in terms of who may access the platform. There is an authentication system to verify the identity of each person that tries to log into the platform. And second, all data exchanged to the platform will be saved on the, as I said, a highly secured cloud-based storage with encryption and blockchain technology.
Very reassuring, thank you. Lisa, we've got some questions about ethics. So let me ask you about AI ethics. Regarding AI ethics regime, how do you see the proposals for legislative intervention to impose additional obligations on the operator of AI systems to comply with an emerging body of standards on the ethical use of AI? And I suppose in general, you spoke about the need to regulate the law, legislative needs. What about regulating technology? I think that's probably what the question is trying to get at, Lisa.
Well, I think it's crucial, and it's the other side of the coin. As I was getting at, there's some aspects of our current checks and balances that may be less efficient in a technology-fueled world. So it's then, and that will happen due to technology, but that means that it's so important to look at how we can regulate the technology. I think the EU AI framework proposal is actually a quite good example of how you can do that, where they look at different type of solutions and they rate them in high risk. Now I should know the exact wordings here, but essentially it's a scale of risk from very risky to less risky. The judicial system winds up in a very risky level. And if it is deemed at a high risk level, then it has to adhere to strict obligations in terms of what kind of checks and balances you need to have in place for the technology before it can be let out into the market. So that will be things like how you can collect and how you can check the data for bias. You need to have a human in the loop and so forth. There's a long list of requirements that goes to try and mitigate the challenges that you have built into this type of technology. So I think that will be extremely important. And here it will also be important that we kind of hook arm with that legislative aspect as well, so that when we build ethic guidelines within the judicial world, it needs to align with what the technology side of things are also what they're trying to regulate, because that will be both sides of the coin going forward.
Thank you. Takashi, in your presentation, you spoke about the flood of information. And I think that's something that practitioners and indeed clients, I think, worry about an awful lot. That one thing about technology is it does encourage people to do information dumps or really give people totally unnecessary floods of information. Sometimes one's own clients do that, and sometimes it's the opposition trying to sort of bombard you. Are there any concrete proposals for that sort of problem?
Thank you, Paul, for the question. And yes, well, as I referred to or discussed in my presentation, we are obviously in a planning phase, and we're trying to, we're in a lookout for good solutions in this regard. But we're kind of looking, one of the topics being contemplated is the manner in which, for instance, contested and uncontested facts are identified in practice, and whether there may be better solutions to identify such facts. I think in this regard, there is an issue about different practices in different jurisdictions. So there is probably effort needs to be made in terms of finding common ground. But we nonetheless think that this is one kind of a neutral approach that could be taken. Contested and uncontested facts are identified in probably across the board in many jurisdictions. So this is one approach that we have been thinking about for quite a while. And another topic being considered is how, asking ourselves this question, how technology can help arbitrators in examining documentary evidence. There may be ways to ask counsel or the parties to be more kind of cooperative in presenting documents by specifying the relevance of documents in one way or another. And I think if we look into all the different, not the cutting edge technology, but rather just looking at the simple kind of standard technology we have at the moment, they are kind of conducive to facilitating arbitrators and examining documents. And so, and we think that not necessarily they are being used quite often at the moment. So there is a need for further promotion in this regard. So we hope these kind of exercises will contribute to preserving or even further strengthening the parties' right to due process and fairness in digitalized proceedings. So I will stop here, Paul. Back to you.
Well, it's a complicated topic. We look forward to development of those ideas. Emmanuel, this questioner says, how can I actually convince my contracting partner to agree to ODR?
ODR, as I said, is a form of online ADR, and we provide a platform which is secure, convenient for the parties to exchange their submissions. Everything is going to be recorded in one place. So you don't have to save your documents on your laptop or elsewhere on another cloud. So it's a highly secure cloud-based storage with blockchain technology. So that is very convenient. And our platform also includes video conferencing system and AI translation. So that will help, assist the parties to break any languages barriers or geographical barriers. So any parties can join from their locations.
Thank you. Speakers, let me ask each of you, let me give you a little case study just to try and play a bit of devil's advocate about technology and to ask each of you really whether technology really works. Let me give you a real life case study. Let's assume that dispute starts very simply. It's a dispute over the calling of a parent company guarantee. The parent gave a guarantee for performance of its subsidiary. The subsidiary didn't perform. A very simple on-demand guarantee. So the claimant starts an arbitration against the parent. And then, lo and behold, the respondent comes along, makes a very, very complicated defense and counterclaim, saying that receivers were put into the subsidiary, the receivers have ruined the business of the subsidiary, your claim is for 100 million Hong Kong dollars, my claim is for $1 billion Hong Kong dollars, and the whole thing escalates and escalates. Does that still render it capable of being resolved by technology? Perhaps I can start with Lisa.
Well, I would. This all comes down to definition to be very lawyering about it, because I would imagine that no dispute today is handled without technology. The question is just where and how. we're not today at a point where a case like that would be solved end to end, or probably should be solved end to end by technology. Looking at where you could actually use it, it depends a little bit on how that process will look like. But anything in there that is a document dump or a very certain repetitive tasks, so you need to fish out things, that will be suitable for technology. There's going to be a lot of potential drafting might be suitable for technology. There's a ton of aspects in there that is highly susceptible for technology, and I think that would go for any dispute. So for me, I would rebut it and say I challenge you to find any case that is not assisted by technology to some degree. And I would be equally hesitant that you would find a case that would be completely can live within the world of technology, although I would find it easier in the second bucket than in the first.
Takashi, do you share that view?
Yes, Paul. Yes, I agree with these on that point. And I think with respect to the case that you put forward to us a moment ago, I think basically there is a question about scope. And there is an issue about party autonomy there, and whether that case falls within that scope is a question to be answered, hopefully by technology, but probably at present times, perhaps better resolved by the determining third party at the moment. But yes, I think there is I think it is a question that could be answered by technology at present times as well. So, but as I referred to in my presentation, my focus or the approach that we are taking is focusing on this residual mechanism about traditional arbitration. But I think the other kind of high-tech or the cutting-edge technology used for proceedings are kind of layers on top of that. So I think all these issues being contemplated are all relevant.
Thank you. And Emmanuel, let's assume it was a very low value dispute. So it started quite simply on EBRAM, and then a very complicated counterclaim comes in. What's your prediction about that?
I think an ODR can work, and actually there's no financial dispute, a financial limit, I mean. So we have two platforms that are capped at 500,000, but we have a standalone arbitration platform, and there's no financial limit. So parties can use it. So my quick answer to your question will be that ODR can work in the case that you have described to the extent that the parties have agreed to use ODR.
Well, what an optimistic panel, ladies and gentlemen. And we started late, but I see Mr. Justice Harris sitting in front of me coming next. So I think I better stop now. And thank you very much for joining us. I hope you found that interesting. Good morning, good afternoon, good evening.
Thank you to the panel for the wonderful discussion. So please stay with us for a quick virtual photo taking. So Mr. Stark, please stay with us for a quick virtual photo taking. So, and our speakers online, please look at your camera, and also Mr. Starr and Ms. Ta, you may be seated and actually look at our camera at the far back in the center. Keep smiling. Okay, 3, 2, 1. All right, let's put our hands together for our moderator, Mr. Starr, and also all of our wonderful speakers. Thank you very much. And now it comes to the last session of today. In this session, we will explore the global recovery from the pandemic, insolvency, and restructuring. May we welcome our moderator, Mr. Justin D'Agostino, MH CEO and partner of Herbert Smith Freehills, and our 4 speakers, the Honorable Mr. Justice Jonathan Harris, Permanent Secretary, Mrs. Zora Mr. Mahesh Uttamchandani, and also Ms. Samira Musayawa. Yes, so let's put our hands together for our moderator and our speakers. So over to you, Mr. D'Agostino.
Thank you very much. Thank you very much. And good afternoon and welcome everyone to this final session of the day. That last session took us into the galaxy, you'll remember. Well, this session is going to bring us back down to earth with a bump. Because this last session is on the field of insolvency and restructuring and its importance in this period in which the world recovers from the effects of the pandemic. Now, 2020 and 2021 have been tumultuous years for all of us, and the impact of the pandemic will be felt economically and socially for many years to come. But for many of us in business and in government, the future is less certain than it used to be. Governments around the world have acted swiftly in the face of the new challenges, enacting legislation to help businesses of all sizes to continue to trade. But that support may not last forever. And so we must now anticipate a growing number of restructurings and a growing number of insolvencies. And it's long been recognized that a dynamic and efficient insolvency regime attracts international investment. It bolsters productivity more generally. So for that reason, on a national level over recent years, we've seen governments jostling to develop new protective measures and insolvency proceedings. Judges, lawyers, academics, and members of government all have a role to play. And they have a role in supporting and developing the international frameworks that currently exist, as well as to ensure that businesses which span across borders and their stakeholders can restructure to fit this new post-pandemic world. And where restructuring is not achievable, those same people will help bring order to the disruption through coordination and recognition of insolvency proceedings, including for all those companies who trade beyond their own jurisdiction. And of course, as night follows day, disputes follow disruption. And we must also have the tools at hand to manage those disputes through mediation, through arbitration, and through the courts. So I'm really looking forward to the next 80 minutes or so and the excellent range of speakers that we have for you on this panel. So we've 4 speakers today. The Honourable Mr. Justice Harris, Judge of the High Court of Hong Kong, who's with me in the room in Hong Kong. So a very warm welcome and good afternoon. And we also have Professor Wisit Wisisoratat from Thailand, who is Permanent Secretary of the Ministry of Justice of Thailand. And we're also joined by UNCITRAL, by Ms. Samira Musayeva, and finally from the World Bank by Mr. Mahesh Uttamchandan. And he'll be joining us with a pre-recorded message and the other 2 online. And I can see they're online now, so a very warm welcome. But we're going to begin today's session with a figure that's well known to many of you, as he is to me, Mr. Justice Harris. And Justice Harris has served as a judge of the High Court in Hong Kong since December 2009, after a very successful career in private practice. And his principal areas of work are insolvency, company regulation, and securities. And he's been a leading individual in the field of cross-border insolvency. He was involved from the very start of the Judicial Insolvency Network, which you will know produced the guidelines for communication and cooperation between courts in cross-border insolvency matters. And Mr. Justice Harris has also been leading in the development of common law mechanisms in Hong Kong for addressing cross-border disputes. So welcome and thank you. We're going to conduct this little session by way of an interview and a bit of a Q&A, just to keep everybody alert and awake. So thank you for agreeing to do that, Mr. Justice Harris.
Well, it's nice to be speaking at an event where there are actually more than 1 or 2 other people present. So it's a very, very encouraging, albeit there's quite a lot of space, I notice. There's quite a lot of social distancing in front of us, but it's still a significant improvement on Zoom.
It's great to be in person. So thank you for all joining us here. Well, look, I think a good place for us to start is probably here in Hong Kong. And currently in Hong Kong, there are no statutory restructuring procedures available under Hong Kong law. And the Hong Kong government announced a new corporate rescue bill, which they said in 2020 was in an advanced stage. Are there any reforms that you think are particularly important in Hong Kong?
Well, I think this subject generally, as most issues of legal reform do, necessitate you stopping and asking yourself, first of all, what is the problem that you think you have, which you're trying to solve? And the problems you're likely to be having in this area are going to depend quite a lot on the different economic and business models that your particular system tends to operate. And Hong Kong's a little unusual in this regard, because of course we have a very agile economy with many small and medium-sized enterprises. And they, with the help, of course, of a certain amount of cash payouts from the Financial Services Bureau, the monetary authority encouraging banks not to issue winding up petitions, and the court simply keeping the registry shut so you couldn't issue a winding up petition for a while, managed to have survived remarkably well. And I think from talking to people in the Financial Services Bureau, the general opinion is that we have very agile business models here, which have allowed the economy generally to weather these problems when we're talking about small and medium-sized enterprises quite well. So if you cross over the road from the convention centre, which is where we are now, and you walk through Wan Chai, which is a type of medium-level general commercial neighbourhood, you're not walking past shops and restaurants which are boarded up, as you might in some other parts of the world. They're thriving, and as most of us will know, booking a restaurant for lunch in Hong Kong at the moment is extremely difficult. So I don't think that we need some kind of terribly sophisticated insolvency mechanisms to deal with the problems that small and medium-sized enterprises are experiencing. For the most part, the issues they have tend to resolve themselves. Sometimes it can be quite cruel. A business is shut, but on the other hand, it gives the opportunity for a new business to be established. The larger business groups are rather different. And what I tend to spend most of my time dealing with, and I have since the court reopened in May of last year, are listed companies. I mean, nearly everything I deal with, certainly of any size, is listed. And commonly what that involves is a business group whose asset owning and operating subsidiaries are in the mainland, but they have a listing in Hong Kong. Normally the listed vehicle will be incorporated in an offshore jurisdiction. Cayman Islands seems to be the most popular at the moment. Then they have intermediate subsidiaries which own the operating and asset owning subsidiaries. And the intermediate subsidiaries are commonly incorporated in the BVI. And of course, the operating and asset owning subsidiaries are incorporated in the mainland. And when they run into problems, the problems are larger and they are much more complicated. So it tends to be those kind of companies which require, I think, the assistance of some changes to our legislation. And what I would like to see is, in fact, quite easy to achieve in the sense of drafting. Whether it's easy to introduce the legislation and get it passed is a different question. But the amendments would be to allow provisional liquidators to be appointed in Hong Kong, specifically empowered to restructure debt. So some form of soft touch provisional liquidation under close court supervision. That's common in many other jurisdictions. The other is very precise, and that is an amendment which specifically provides that the Hong Kong High Court can wind up any company listed on any board that our stock exchange either has now, so the main board or the gem board, or may establish in the future, say a technology board, regardless of where the company is incorporated. That would seem to me to be a jurisdiction that there should be no argument about, but there is in fact an argument about it. It involves a company called Shandong Chengming Paper, and that's going off to the CFA sometime in the future. But I think most of us would expect the Hong Kong court to have the jurisdiction to wind up listed companies. So I would be happy with actually quite limited reform, and I think most practitioners would.
I mean, that's good. We know that LegCo's got a busy docket, but you've given them something else to get on with, hopefully. So that's good, and good to be so specific. I mean, you've talked about mainland China, and of course, so much of what all of us do in Hong Kong has some connection to the mainland when it comes to business and commerce. When we think about the mainland courts, do you consider it likely that they will be increasingly willing to provide assistance in Hong Kong insolvency proceedings following the mutual recognition and assistance protocol that was introduced?
Yes, I think they will, but it's going to be a slow process. The system in the mainland of dealing with insolvencies and corporate rehabilitations is very different from the Hong Kong one. And that reflects their economic model, it reflects their social and political imperatives, and it reflects the way the the courts themselves operate. So by way of illustration, for example, there are, I suppose, two of us in the Hong Kong High Court now who spend most of our time dealing with company matters, not all insolvencies, some shareholder disputes, corporate finance kind of stuff. In Shenzhen alone, there are 12 full-time insolvency judges, and until last year, when they introduced a pilot scheme for personal bankruptcy, and it's the only jurisdiction where there's any kind of personal bankruptcy in the mainland, they dealt exclusively with corporate cases. So you might ask the question, well, what are they doing? You know, is Shenzhen collapsing economically? We don't read about its early commercial demise. No, it's their job is rather different to the job that I do. I decide legal issues and factual disputes which are relevant to either the insolvency process or the restructuring process. Their job is much more like a liquidator. So they're much more actively involved in the administration of the liquidation process. They're much more actively involved in the restructuring process as well. Now, that means that many of them are very familiar with insolvency, of course, but it also hints at a complication for them, and that is that they are having to have regard to different considerations to the ones that I have to have regard to. They know that they have to have regard to social stability. They're not meant to be shutting down factories if they can possibly avoid it. They've got to be taking into account the concerns of government bodies and actively speaking to them. So it's not simply a matter of sending a letter of request to Shenzhen or Xiamen or Shanghai, the three jurisdictions which are party to the agreement, and assuming they're immediately going to react with the speed with which I can. They are going to have to work out how recognition of our appointments is going to fit into their system. And I know from talking to judges there's a degree of caution. So it's going to be a relatively slow process, but it will develop. My own view is that the most interesting area is in the restructuring field. And we've already seen an example of that because I've recognized the HNA reorganization. So that's the area which I would expect to see developments, particularly if companies like Evergrande are going to restructure and they're going to use schemes of arrangement in Hong Kong to restructure their offshore debt.
Well, it sounds like an important positive development at least, but still a road to go down. We've heard one case already mentioned by Mr. Justice Harrison. We're going to talk about a second case for those of you who thought you were getting off the hook today on some real law, and that's the case of Gibbs. So I want to move on to the continuing use of the rule in Gibbs to resist recognition or to resist recognizing the effect of foreign insolvency proceedings. And I thought you could maybe just tell us a bit about that rule to get everyone sort of warmed up and back up to speed on it. But the real question is, do you consider this to be a help or a hindrance in restructuring in the modern commercial world where groups operate across so many jurisdictions and they may not be centered in Hong Kong?
Well, the rule in Gibbs is a rule named after a case. It's an English Court of Appeal decision, the date of which I can't recall now. I think it's the end of the 19th century, 1898, I think. And what that decides is that a debt can only be compromised in accordance with the law which governed the debt. So if a bank lends money to a company and the financing documents provides that Hong Kong law governs that debt, then as a matter of Hong Kong law, only a legal process which itself is governed by Hong Kong law or part of Hong Kong law, will be recognized as effective to compromise that debt. And this is mainly relevant in the, at least for present purposes, in the area of restructuring using things like schemes of arrangement. So if you introduce a scheme in England which purports to compromise the debt governed by Hong Kong law, then you wouldn't normally expect the Hong Kong court to recognize that scheme as effective, unless the creditor had submitted to the jurisdiction of the English court, in which case the situation would be different. So why is this contentious? How's it relevant? Because at first blush you might think that it sounds eminently sensible, it's what you would expect. Well, the problem is that when you're dealing with transnational business groups and transnational debt, it means if you introduce a scheme in London and it purports to compromise the debt governed by various different legal systems, including in Hong Kong, the scheme may be recognized in some, Singapore now, because they no longer follow Gibbs, but not in others like Hong Kong or, for example, the Cayman Islands, the BVI and Bermuda, where I understand that they still follow Gibbs. So there is a view, there's certainly an academic view, that Gibbs is a hindrance. Now, whether or not you see it as a hindrance takes you back firstly to the consideration that I was mentioning at the outset, precisely what is the problem that you're concerned with. It also rather depends on the situation of your jurisdiction. So views on Gibbs to some degree, at least outside the academic area, depend on whether you benefit from Gibbs, whether you suffer from Gibbs, or whether, as in the case of, say, the US, really it doesn't matter very much, because the use of the US dollar, the use of US law, the long arm reach of Chapter 11 means that they don't worry too much about that issue. They certainly don't have the rule in Gibbs. At the moment, I think the position is it doesn't in fact cause much in the way of practical problems for us. It causes problems for systems which would like to expand the reach of their restructuring regime, but are in some way restricted because they don't have very much debt governed by their law. But in the case of Hong Kong, most of the debt is either governed by Hong Kong law or it's governed by commonly New York law. And the New York court will recognize a Hong Kong scheme as effective to compromise New York law governed debt under Chapter 15. So from our point of view, it's a kind of win-win situation, really. But for other jurisdictions, it isn't. So it's not something that I feel Hong Kong has a pressing need to encourage to change. If anything, if one's commercially minded and being a little bit selfish, Gibbs is quite attractive and works quite well for us.
Just while we're talking about extra-jurisdictional issues, I mean, we've seen various jurisdictions introducing provision for restructuring debt, provisions which appear to be intended to have extra-jurisdictional effect. What are your views on that, Judge?
Well, it's the kind of thing which sounds in theory like a really good idea. It's the kind of thing that nobody could disagree with. But I approach concepts like good forum shopping with some circumspection. I mean, firstly, good forum shopping normally in practice means shopping in my shop, not somebody else's shop. And if you commercialize, if you try and commercialize, you try and monetize your legal system, you run the risk of just entering into some kind of competition with other systems, which is not really helpful and not particularly principled, I don't think. But I do think that one needs to stop and ask deeper, more serious questions. So if you are going to purport to restructure the debt incurred by businesses in other jurisdictions where there are creditors located, you have to ask questions like, how in touch is your system with the other system? So in the case of Hong Kong, we do have a slightly unusual economic and business model. Obviously, the mainland is completely different. Is a court in somewhere like the Cayman Islands, because they're thinking of introducing this kind of new legislation, really very well placed to assess what is suitable for Hong Kong, what will work, whether Hong Kong debtors can be trusted? Do they really understand why Hong Kong is generally a little bit cautious about debtor in possession systems? And you find that caution extends, in my experience, across the whole spectrum of potential creditors, whether it be banks who are very sophisticated, all the way through to the trade unions. There is a general feeling that debtor in possession models, however attractive they may appear to other systems, perhaps are not suitable for Hong Kong. And I think it ill befits a jurisdiction a long, long way away, which probably isn't very familiar with the imperatives and problems we have here, to purport to intrude into our economic activities. So I think one has to think fairly carefully before being too enthusiastic about introducing extraterritorial systems and trying to operate them.
Well, look, that's real food for thought for us, and I think these are the sorts of topics that are going to be increasingly come up with for practitioners over this next period. And you mentioned Evergrande and the like, but you know, post the pandemic, as I said at the beginning, I think we're going to be grappling with these issues. You're not off the hook. You can't leave the stage, because there will be some Q&A at the end, hopefully, and we'll get some questions from the audience online and in the room. But we're going to keep moving, and I'm going to introduce our second speaker now, and that's Professor Wichit Sorat, who's Permanent Secretary of the Ministry of Justice in Thailand. The professor holds a number of positions, actually, in civil and criminal, in the civil and criminal justice spheres in Thailand. He's recognized at the international level as a prominent figure in the development of frameworks for international trade law, particularly in relation to insolvency. And he's synonymous, actually, with the Thai business reorganization and debt restructuring law, which was first introduced as part of the Thai bankruptcy law in 1998 as a result of the 1997 economic crisis. And he's very famous for his role in that, not in the crisis, in the law. But he's also a former chairperson of Working Group 5 on insolvency law, and having held the chair of UNCITRAL not once, but twice. He's the perfect addition to our panel today. And he is going to explain the new legislation that's been drafted in Thailand with a view to improve processes for micro, small, and medium enterprises. So, Professor Sawadee-kap, and over to you.
Thank you. Good afternoon, Justin. Good morning, good afternoon, everyone. It's been a while that I have to come back to speak on insolvency, but I try my best to put you through the development in Thailand. But before I start telling you about what we are dealing at this moment, I think everyone is agreeing that the situation of the pandemic that affect the economies in every country is something that would put many countries in a very difficult situation. Thailand is no exception. But I would say that at least in some particular point, we were doing quite well because of the crisis that we had in 1997. The 1997 definitely reshaped the financial institutions and the bankruptcy law in Thailand, and make sure that we have some reasonable framework to deal with the issue. So with the disconnectivity of the traveling and many things that affect the growth of economies in the country, we see that many industries have collapsed, mainly the traveling, the tourism, hotels, and also other industry surrounding that. And that, of course, affects other people in terms of their income. So you see that the lockdown in the country really stop or freeze many things that would create or generate incomes for many people. So I would see this as the systemic bankruptcy that will come up. The Bank of Thailand predict that maybe quite a large amount of debt would be unpaid, and that is true. And we see that the government, although they provide these stimulant funds, but that would perhaps only kill some of the problem. But in terms of the insolvency that we can see that will come in the future, it will definitely come. But having said that, Justin, I think one main reason that I can say is that the situation is not that grave like in 1997. No one expects a bailout because every country is subject to that kind of difficulty. There is perhaps a strong financial institutions system in the country, and therefore the banks seems to do quite well in terms of mediating and giving some funding to the private sectors in order to make sure that they don't suffer it too harsh. But eventually, I think we come up to the point where unless this pandemic come to an end somehow, a number of insolvency will happen. From my experience at the moment, I think we are now coming to the point where we can perhaps live with the pandemic. It may become the endemic very soon, and we see people now traveling and open up other countries, and also some other industry is now coming back to the issue. So this is something that perhaps I can share with you, that how we see the situation. During the crisis, Justin, we also envisage that many companies have come for the restructuring. The Thai Airways, which is the biggest airways in the country, and the No Air Airways is also came through the reorganization. We have a lot of hotels coming in the way. So the law that we provided in 1997 and 1998 seemed to cope with this problem at some point. But now, having said that, I think it might not be enough to really help the system without looking at the way to resolve the problem. Thailand look at the two sets of legislation that we are now drafting and have proposed it to the government. The first one, I think we have heard that Thailand took part in the model law and cause of insolvency for a very long time, and that is now become the draft legislation. So I must tell Samira from UNCITRAL that you are now on the right path to talk to me now, and that draft is being reviewed by the government, and I hope that it may come up as a part of legislation very soon. The second part would be something that require a quicker attention. The legislation on the bankruptcy law in 1997 that we introduced the more like the chapter 11. However, as Justice Harris has mentioned, there is the hesitation of allowing the debtor in possession to be set as a rule in that law. So the law would still, in that possession, allow the insolvency practitioner to be mainly the one who get involved with the restructuring. But the law somehow gives some room to the debtor to perhaps, if they can convince 2/3 majority of the votes to go for them, 1/3 the majority of the vote to go for them, they could be elected as a plan preparer in that situation. We come up to the point of the MSME, or maybe the smaller business. The law that we are now proposing, or the draft legislation, we are now separate the size of the reorganization into two tiers. The first tier is generally in the same way as we have with the existing law, and you would require to have at least $1.5 million to file for that reorganization. But of course, with that amount of money, it would be very little when you look at the very large company in the country. But we are now encouraging the small, medium, and maybe much smaller companies to have a chance to get reorganized under the law, under the new law. So we create a second tier. So anything lower than 50 million baht in debt or 1.5 million baht USD could have another chance to go for the reorganization under this law. And the law would provide a much quicker reorganization. The first thing would be that the time for the plan preparation, it is much shorter than the one provided under the existing law by half. The very different would be the debtor imposition. Under the new draft legislation, the draft legislation provide that the DIP would be the one that you have, unless they are not trustworthy and they would be suspect to fraud, then you can do away with that. But this is the new improvement. I understand that in 1997, when we introduced the debtor imposition in Thailand, that was not at all accepted. Although we had some chance of compromise, but that become something that I think it might be the time that we eventually agree to the debtor imposition approach. And apart from that, I would say that the new legislation also provide for something that available under the UNCITRAL draft legislative guide. That is the pre-package or pre-packed approach. So in this solution, we see that you don't have to come to court for the automatic stay. If you don't need it, you can do it outside the system, and then you can come to the court for the approval of the plan once it got adopted by the creditors of required classes in that regard. So this is the major changes in the law that we are now proposing, and I hope that it could become the law very soon, and that it would come to eventually be needed during the pandemic moving for the endemic. By saying that, I would say something a little bit further, because we have the bankruptcy in a very systemic approach. It is inadequate to say just that if you have this systemic bankruptcy and then you would rely on the normal mechanism that would provide a help. I don't think the court can deal with that in the large scale. We had the same problem in 1997, and the working with the government outside the court system to be in line with the bankruptcy procedure in the court is something we do need it. In this regard, the government has instructed the Bank of Thailand to work together with the Ministry of Justice, the Court of Justice, in order to make sure that somehow you would need to have mechanism for the conciliation outside the court. The Ministry of Justice, the Court of Justice, and also the Bank of Thailand set up the scheme. And the scheme is to ensure that if the bank can somehow reduce or making the haircut and making sure that that can be restructured outside the court system, they can do so with the three agencies working together. We have set up the platform that the debtors, from the very small to maybe the large one, can undergo the mediation outside the court system. And this program has been placed in the country. We see that a lot of companies and individuals are having the negotiation with their creditors and come up with the resolution among themselves. So by seeing this situation, I would say that the effort of the government to perhaps ensure that the amicable solution between the creditors and debtors can be happening in ERA is something that we do need. In fact, we also have other piece of legislation that they are looking at, but this is something that is quite controversial. There were discussion about perhaps the stay for those who would be subject to the eviction from their houses, and by having the stay, the creditors could be compensated through the scheme of the government, but that is not yet become finalized, and I hope that we would be able to deal with that very soon. So this is the situation that happened in Thailand, Justin, and I would be very happy to answer your question and any other if needed. Thank you.
Thank you. Thank you, Professor Kopkun Kap. It's great to see actually this new legislation being drafted, especially in this period. Actually, most of you probably read coming into the conference today, some very good news coming out of Thailand that only today they've opened their borders to 60 more countries. And I can't believe that none of us are looking forward to our first trip to Thailand after 2 years. Anyway, we'll come back to that. Professor, there will be questions for you, but we're going to keep them all, I think, until the end as we get questions in from the audience. So thank you very much. And again, don't go anywhere because we'll call on you before the end of the session. Our next speaker is Samira Murayeva. And Ms. Murayeva is the Senior Legal Officer in the UNCITRAL Secretariat and has been with the Secretariat since 2004. And she's now Secretary of Working Group 5. And she's written extensively on the model law. And as part of Working Group 5, she's focused on civil asset tracing and recovery and the applicable law in insolvency proceedings. And these are the subjects that she is due to talk with us about today. So thank you very much, and over to you. Now I can see your lips are moving, but we can't yet hear you. I don't know if it's an issue at our end or yours.
No, it's from my end. I'm sorry for that. Thank you very much for giving me the floor. Greetings to all from Vienna. My name is Samira Murayeva. I'm the Senior Legal Officer in the UNCITRAL Secretariat and Secretary of Working Group 5 that deals with insolvency law aspects. The working group prepared numerous UNCITRAL insolvency texts on domestic and cross-border insolvency issues. And I'm honored to be in this session. This is the past long-serving chair of that working group, Visit Sorat. Most recently, the working group completed the work on the legislative recommendations on insolvency of micro, small business. It is expected to finalize the commentary to those recommendations this December. UNCITRAL will, of course, be happy to learn that its texts already used for reforming to address specific characteristics of such enterprises and their special needs in financial distress. I'm not, however, going to talk about this most recent text of UNCITRAL, since I was asked to introduce this audience to new topics that UNCITRAL decided to take up this July in the area of insolvency law. Those topics are civil asset tracing and recovery and applicable law in insolvency proceedings. Both topics were referred by the Commission to its Working Group 5. The Working Group hasn't yet had a chance to consider them. It's expected to do so at its 59th session this December. My presentation is therefore based on the discussion of the topics in the Commission and results of the exploratory and preparatory work that were undertaken by the Secretariat on those topics so far. First, some background information about the topic of civil asset tracing and recovery. The origin of its consideration in UNCITRAL can be traced back to December 2017, when the United States proposed to Working Group 5 that it should prepare model legislative provisions on the topic. Justification for the work was that some jurisdictions do not have adequate tools for asset tracing and recovery in insolvency proceedings. Some jurisdictions may not even know that such tools exist, and, in fact, are successfully used. It was submitted that when such tools exist, there are no uniform procedures to facilitate access to them by foreign parties. The subject, it was argued, was linked to commercial fraud, powers of the insolvency representative, and UNCITRAL model laws on cross-border insolvency. Working Group 5 was therefore considered an appropriate forum to undertake the project. As regards the approach to work, it was suggested that a set of options should be prepared from which jurisdictions that are interested in enhancing cross-border cooperation in this area could choose for enactment in their domestic law. The working group, at its 53rd session in May 2018, expressed support for the proposal, but deferred decision on it to the Commission. The Commission, in turn, requested the Secretariat to prepare a background study on the topic. The following year, it received another proposal from the United States on the topic. That proposal contained an inventory of civil law tools found in both common law and civil law jurisdictions that proved to be helpful for tracing and recovering assets in insolvency proceedings. The United States proposed that the Commission should convene a colloquium to expand that inventory, in particular with asset tracing and recovery tools from civil law jurisdictions. It was also proposed that the colloquium should delineate the scope of a future UNCITRAL work on the topic to avoid that discriminatory law issues. Such a clear delineation was considered necessary in response to concern that the United States proposal is closely linked with criminal law and might therefore be outside the mandate of UNCITRAL. Reference in that context was made to the work of numerous international organizations dealing with asset tracing and recovery, in particular those money laundering, transnational organized crime, and corruption. In addition, when the Commission considered that proposal, some questioned why the work should be limited to the area of insolvency law, when asset tracing and recovery is in fact very much pertinent in other areas of commercial law, for example, enforcement of collateral awards. At its 52nd session in 2019, the Commission requested the Secretariat to organize a colloquium to consider the elements of a possible toolkit on asset tracing and recovery, and supplement the existing background study with information on the practices of civil law jurisdictions. The colloquium was expected to examine both criminal and civil asset tracing and recovery, consider tools developed for insolvency law and for other areas of law, and discuss proposed asset tracing and recovery tools in conjunction with existing international instruments. The colloquium was held on 6 December 2019, and its report was before the Commission at its resumed 53rd session 2020. A wide range of asset tracing and recovery tools were discussed at the colloquium, and relevance of other organizations' work was again highlighted. During discussion, close interaction with criminal law issues again became apparent, even if the project were to be limited to the insolvency proceedings. Experts had different views on the objective, form, and methods of work on the project, in particular, whether it should be limited to insolvency proceedings. At its 54th session, 2020, the Commission considered the report but decided to delay decision on future work on that topic, pending its consideration of the results of the colloquium on the other topic proposed for work by UNCITRAL in the area of insolvency law. That other topic was applicable law in insolvency proceedings. The colloquium on applicable law in insolvency proceedings didn't take place as scheduled in May 2020 because of the outbreak of COVID-19 and lockdown measures. And this brings me to the second arrow on this slide, applicable law. The topic on applicable law in insolvency proceeding has its origin in an oral proposal by the European Union in 2018 to the Commission. It was tabled as an alternative to the work by Working Group 5 on civil asset recovery proposed by the United States. The written proposal by the European Union on behalf of its member states to the Commission followed in 2019, and an idea emerged at that time that Working Group should take up both topics and work on them in parallel. It was considered that the work on the topic would close the gap in the existing UNCITRAL policy. Its goal would be harmonization of choice of law rules in cross-border insolvency cases. Such harmonization was considered necessary for trade and commerce because the current rules for applicable law in insolvency proceedings were inconsistent or they might not even exist, which increased uncertainty and unpredictability in cross-border insolvencies. Reference was made to lex fori concursus as a guiding principle with exceptions, for example, for ranking unsecured claims or for intellectual property and other intangible rights. Coordination with the Hague Conference on Private International Law was considered essential. At its 52nd session in 2019, the Commission recognized the importance of the topic, but also acknowledged its complexity. It also acknowledged that the existing UNCITRAL border laws on cross-border insolvency did not address it. The Commission requested the Secretariat to organize a colloquium to carefully delineate the scope and nature of the work. With some delay because of the pandemic, the colloquium took place online on the 11th in cooperation with the Permanent Bureau of the Hague Conference on Private International Law. The colloquium examined various aspects, including applicability of lex fori concursus to avoidance actions and security rights. As in civil asset tracing and recovery, issues arising from digital aspects and digital assets were also examined. Next slide, please. At its 54th session last July, the Commission considered reports on both colloquiums and decided to commence work on both topics. Consider that indeed, inconsistent and fragmented legislative approaches and gaps existed to treating those topics at the national level. UNCITRAL work was considered would aim at harmonization of those approaches, filling in gaps, and also tackling digital aspects. The Commission was of the view that the work products on the topics would usefully supplement existing UNCITRAL insolvency text and should build on them. In the light of the relevance of the topics to insolvency proceedings, both were referred to Working Group 5, and the Working Group was requested to treat them equally. The decision on the form that work on both topics could take was deferred to a later stage. With respect to the topic of civil asset tracing and recovery, the Commission explicitly requested that its scope should be limited to insolvency proceedings. But the results of the work on the topic might turn out to be helpful in other areas of law, where civil asset tracing and recovery are relevant. The Commission also considered that it might decide at a later stage to expand that project to other areas of its work if necessary. Next slide, please. Since then, 2 expert group meetings were held in September on both topics, and papers were prepared for consideration by the working group. This slide gives you an overview of what was used as a basis for preparing the paper on civil asset tracing and recovery in insolvency proceeding that the working group expects to consider at its 59th session in December. Of course, first of all, UNCITRAL insolvency text. In particular, their detailed provisions on protection and preservation of the insolvency estate and restoration of its integrity. There are also numerous provisions on powers of insolvency practitioners in that context, including with respect to avoidance proceedings and actions against directors. The text and ongoing projects of other international and regional organizations, and you see reference to them on the screen, UNIDROIT, Hague Conference, UNODC, European Union, as well as national laws and case law, also informed very much the results of the preparatory work. Next slide, please. This slide gives you an overview of what was used as a basis for preparatory work on applicable law. Again, the starting point was UNCITRAL texts, especially since recommendations 30 to 34 of the legislative guide on insolvency law adopted by UNCITRAL in 2004 explicitly address this topic. They set out first rules for choosing law applicable to pre-insolvency claims and refer to lex fori concursus as the main law applicable to post-commencement insolvency aspects. 2 exceptions to lex fori concursus are provided with respect to financial and labor contracts, and the guide recommends that additional exceptions to lex fori concursus should be very limited. The travaux preparatoires of those recommendations is quite informative, both about the extent of the consideration of those provisions in 2004 by the working group and the Commission, which was very limited in fact, and about the connection of recommendations 30 to 34 with other parts of the guide, in particular recommendations on treatment of security interests and financial contracts in insolvency. Because those recommendations are part of the coherent system in the legislative guide, it explains choices made with respect to drafting recommendations 30 to 34. The slide also refers to the past consideration of the topic in 2009 and 2013 as part of proposals for future work by UIA and III. Those proposals indicate that after the adoption by UNCITRAL of recommendations 30 to 34, the work on the topic was considered unfinished. The working group was repetitively coming back to that topic with a view of reviewing the content of 2003. Next slide, please. So far, the Secretariat identified the following main issues with respect to the civil asset and recovery topic. There are a great variety of asset tracing and recovery tools around the world. Although named differently, they purport to achieve the same result, either to identify and track.
I think we might have lost Samira.
And safeguards against their abuse are imposed, especially in the light of the implications on human rights. Freedom of movement, adequate standard of living, right to property, due process. Main obstacle for effectiveness of asset tracing and recovery tools across borders is the lack of their rapid cross-border recognition and enforcement. In particular, provisional or interim measures, which are the most effective in asset tracing and recovery, are excluded from the scope of international instruments dealing with recognition and enforcement of judgments, including the Institutional Model Law on Insolvency judgments of 2018. And uncertain issues arise as regards digital aspects. For the Secretariat to move forward with this project, it needs a clear indication from the working group about the objectives, scope, and nature of the work. Next slide, please. Many issues arise in connection with the applicable law project. To unpack them, a step-by-step approach may be justified. Applicable law issues may be tackled first in the context of a simple scenario, insolvency with single debtor with assets and creditors, house lawyers. How applicable rules would operate in that case without causing problems with cross-border recognitions of effects of lex fori concursus. Then, more complicated scenario, how applicable rules would operate in concurrent proceedings in several jurisdictions commenced with respect to the same data. And finally, enterprise group insolvency of complexity. With the purpose of avoiding the commencement of parallel proceedings, for example, the model law envisages that insolvency entity in foreign proceeding may give an undertaking to treat local claims as they would be treated in local proceedings if they were to be commenced. However, that model law does not explicitly address applicable law issues. From the outset, the scope of lex fori concursus would need to be clearly defined by clearly separating non-insolvency from insolvency, procedural insolvency issues from substantive insolvency issues. Issue would arise whether lex fori concursus encompasses also choice of law rules. Views are different on that aspect depending on whether one talks about substantive insolvency law issues or purely procedural ones. And applicable law to digital aspects would need to be considered, keeping an eye on what UNIDROIT is currently doing in the context of its project on digital assets, in particular subgroup 4, deals with taxonomy and private intellectual law. Main issues for moving forward with this project is whether amendment of recommendations 30 to 34 are envisaged or preparing a separate text on the topic. Next slide, please. And this is my final slide. For those interested in those two topics, please follow up at the web page of the working group. Please move to the next slide.
Samira, I think we heard that that was the final slide. We were having a little bit trouble hearing you in the room, but thank you everyone for persevering, and hopefully the online participants could hear you well. But thank you for that tour de force, a very detailed presentation of everything that's been done by the working group. I'm sure we'll have one or two questions on that. But before we do that, we've one pre-recorded presentation from Mahesh Uttamchandani from the World Bank, and he is the practice manager for financial inclusion, infrastructure and access in the finance, competitiveness and innovation global practice at the World Bank Group. And he manages their global work on payment and market infrastructures, responsible financial access, and importantly for today, insolvency. And he's a board member of Insol International. So we'll start his recording now. And for those of you who haven't managed to hand any questions up to one of the team here, please do, and we'll have a bit of a Q&A before we wrap up for the end of the day. But we'll hear the recording first. Thank you.
Good morning, good afternoon, good evening. Thank you for this kind invitation to speak. I would like to say at the outset that what you're going to hear from me today are my own views and do not necessarily represent the views of the World Bank, its shareholder nations, or its executive directors. Now, as some of you may know, the World Bank is the designated standard setter, along with the UN Commission on International Trade Law, on insolvency law. And in that capacity, we convene a global task force of experts from common law and civil law jurisdictions, representing both OECD countries or advanced economies and emerging markets, to periodically issue the World Bank principles for effective insolvency and creditor-debtor rights. The principles, together with the UNCITRAL legislative guide, represent the global standard on insolvency as designated by the Financial Stability Board. We also provide technical assistance to countries in every region of the world on improving their insolvency systems. In the past year, we have looked at the impact of COVID-19 on insolvency law and practice around the world and have prepared several papers available on our website on various aspects of insolvency, including out-of-court workouts. Before I dive into my remarks, I want to alert you to three important papers that we'll be publishing soon. In January, the World Bank will launch its 2022 World Development Report. This is a flagship publication of the World Bank Group, and this forthcoming edition will, for the first time, have a chapter dedicated to insolvency. We will shortly be launching a corporate debt restructuring white paper that looks at issues of non-performing assets from all aspects of the financial sector, including insolvency. Finally, together with governments around the world, we are engaged with the Financial Stability Board in a fact-finding research initiative on the state and practice of out-of-court workouts. The paper setting out the findings of this initiative will also be launched over the next few months. Now, although the impact of the pandemic is still being written when it comes to insolvency, policy, and COVID, I believe we will look back on the pandemic as having had three distinct chapters or phases. Chapter 1 was about the temporary measures. This is what happened in early 2020 when governments introduced short-term measures to keep businesses afloat and prevent an immediate wave of bankruptcies. Chapter 2 is about the taper, the winding back of the short-term measures to return insolvency systems to their default settings. In some countries, this has already happened, and in other countries, it's underway. Chapter 3 is about the reforms for the future. We're seeing many countries implement or planning to implement longer-term reforms to their bankruptcy frameworks to assist you with the post-COVID recovery. Some of these reforms have already been implemented and others are still being worked through. But getting these reforms right is going to be critically important because the impact of the pandemic has been strikingly regressive. The proportion of people living below the extreme poverty line of $2 a day rose for the first time since 1998. At the World Bank, we estimate that between 120 and 124 million people have fallen back into poverty in 2020 alone, and that this is projected to rise to between 143 and 163 million people in 2021. In 2020, 8.8% of global working hours were lost compared to the fourth quarter of 2019. That's equivalent to 255 million full-time jobs. And young people aged 15 to 24, as well as women, were more likely to lose their jobs than other sectors of the population. Female-owned businesses were also about 6 percentage points more likely to have closed their business than male-owned businesses. Now, when we look back at the phase 1 temporary emergency measures, we can see that things may have been a lot worse were it not for widespread emergency policy measures implemented in the immediate onset of the pandemic. The purpose of temporary insolvency reforms was to flatten the curve of insolvencies by creating breathing room for businesses, individuals, and financial institutions, and in doing so, prevent widespread economic distress. Towards the end of last year, we conducted a comprehensive survey with Insol International to try to understand the content of these measures and how widespread they were. Over 95% of the countries we surveyed had made some sort of modification to their insolvency framework in 2020. There were 3 common types of measures. The most common type of measure was some form of relaxation of the requirements for debtors to repay their debts. And about 80% of the countries we surveyed did this in some form, whether through moratoria, extensions of loan timetables, or even the extraordinary measure of closing the courts. The second most common type of measure were those designed to block or make it harder for creditors to initiate recovery or bankruptcy proceedings. Slightly under half the countries surveyed did this. The third most common type of measure were changes to legal duties, in particular, shielding company directors from their obligations to file for bankruptcy. Slightly under 1/3 of the countries surveyed did this. In terms of a timeline, most measures were implemented between March and April of 2020. Most were fixed in time, but able to be extended as well. And another way that countries implemented the reforms was simply to tether them to a state of emergency, meaning that the measures would remain in place so long as the state of emergency did. So that, in a nutshell, was phase 1. But before moving on to phase 2, or the taper, I think it's worth addressing a key underlying issue: non-performing loans and insolvency filings. As I previously mentioned, the premise for the emergency measures described earlier was that if no action was taken, there would be a drastic increase in business and personal bankruptcy and a rapid widespread rises in non-performing loans. But did this turn out to be correct? Unusually for a recession, the available data suggests that the COVID-19 pandemic era has seen bankruptcies decline so far, although that data is a little bit complicated because if you look just at large value insolvencies, there actually was an increase. But in April 2021, the IMF estimated that 6 months into 2020, bankruptcy filing rates were sitting probably at about 80% of pre-pandemic levels. Compare that with 6 months into the global financial crisis 10 years ago, and bankruptcy filings had increased to 150% of their pre-crisis levels. So this confirms our analysis of insolvency filing rates in the second and third quarters of 2020 as well. In most countries, they were flat or declining. Similarly, the ratio of non-performing loans in most countries had not changed to any significant extent, at least in the vast majority of countries. Now, it's possible that the temporary measures and fiscal support have had the effect of deferring insolvency filings and non-performing loans. It's also possible that after the measures are withdrawn, filings and non-performing loans will increase. The underlying metrics of firm health strongly support the conclusion that an elevated level of business failure is possible. For example, the IMF has forecast that about 1/5 of small and medium enterprises will have negative net equity by the end of 2021. What is not yet clear is whether this will translate into bankruptcies, and when it does, how widespread that will be. Two possible forecasts that do not appear unreasonable are that on insolvencies, there will be a predicted rise of about 20% by the end of 2021 in advanced economies, and that is what the Bank for International Settlements estimates. On non-performing loans specifically, modeling by the Economic Governance Support Unit of the European Parliament suggests increases in the rate of non-performing loans in Europe of between 30 and 60% in most European jurisdictions, and over 150% in the hardest hit jurisdictions. In our 2021 virtual legislative and regulatory colloquium in partnership with Insol International, we canvassed the views of insolvency legislators and regulators on temporary and forward-looking insolvency measures. While there is a divergence of views in those we surveyed, most regulators indicated that they are preparing on the basis that at some stage in the near to medium term, a substantial rise in insolvencies will occur. Now, looking at the phase 2 part of the pandemic, the tapering of temporary emergency measures, if it follows from everything we've seen in phase 1 and from the predictions that a key challenge for policymakers is to decide when and how to wind back the temporary measures. To move too quickly risks the widespread business failure that the temporary measures were meant to prevent. To wait too long risks a proliferation of so-called zombie businesses lacking either a pathway to viability or a pathway to market exit, and restricting the availability of new credit. One of the key takeaways from our legislative and regulatory colloquium was that advanced and emerging economies have a strikingly different attitude towards tapering. For advanced economies, typically the concern is about avoiding widespread business insolvency and protecting the health of the financial sector. For emerging economies, typically the urgent challenge is the fiscal position of the government and the need to restore budgets with new taxation measures and reduced spending. We've conducted a survey of the extent of the tapering in over 100 countries, and we're currently in the process of interpreting those results, and the findings will be published in the next few months. However, our preliminary finding is that most countries have fully wound back their temporary bankruptcy measures, and many had done so by the end of 2020. Australia is a good example of the difficulties involved in working out the right time to finalize this tapering process. Having made significant progress on the virus in the country by the end of 2020, Australia ended its temporary personal bankruptcy measures in January 21, and the equivalent measures for businesses in March of 21. In July, the Delta variant emerged in Australia, and since then, most of the country has been drawn into extended lockdowns, while most of the rest of advanced economies have been in the process of opening up. While there has been fiscal stimulus, the temporary bankruptcy forms were not reintroduced. Now, turning to phase 3 or future-minded reforms, one of the ways countries can facilitate a smooth transition from crisis to recovery is to implement long-term reforms to bankruptcy frameworks to strengthen their financial sectors for the post-COVID recovery. There are 2 reform themes I really want to try and discuss with you. First, out-of-court frameworks for debt resolution, and second, new guidance for bankruptcy frameworks that cater to micro, small, and medium enterprises. Now, on out-of-court workouts, in the next few months, we will publish a white paper on the corporate debt overhang, and one chapter of this is concerned with insolvency systems, and in particular, frameworks for out-of-court workouts. I want to briefly share 2 findings from that work with you. The first is that despite the known benefits of informal restructuring tools, they are less common than formal insolvency tools. Out-of-court workouts are private agreements between creditors and debtors with limited or no judicial involvement, also remain relatively uncommon. Our analysis suggests that the jurisdictions in which there is a framework or guideline or set of agreements for the conduct of out-of-court workouts enjoy greater creditor participation in this process. This matters generally because in jurisdictions where creditors regularly use informal restructuring tools, economies tend to have higher levels of access to credit. It matters in this moment because the anticipated rise in insolvencies will test the court systems of even advanced economies. In this context, changes to insolvency systems that have the effect of diverting workload away from the formal court system will be of great utility. The second finding of the insolvency chapter of the corporate debt overhang white paper has to do with the mechanics of liquidation and restructuring. As some of you know, there are so-called separate entry systems in which an indebted company can either go down a path of restructuring or a pathway for liquidation. And this is contrasted with single entry systems in which there's one entry path that can branch off into either liquidation or restructuring. We found that the separate entry systems model is associated with substantially higher rates of creditor recovery in aggregate. Now, turning to SMEs, I touched earlier on the fact that the World Bank serves with UNCITRAL as the joint standard center for insolvency and creditor rights. And the World Bank's principles for insolvency and creditor debtor regimes was first published in 2001, and we've since then updated it periodically. This year, we published revised principles, and UNCITRAL has adopted revised legislative recommendations to its legislative guide, both to address the issue of micro, small, and medium enterprises. The pandemic has amplified the importance of insolvency systems that are inclusive of MSMEs because MSMEs have been disproportionately harmed in the course of the pandemic. Our World Bank Business Pulse surveys show that in the course of 2020, MSMEs were more likely than large businesses to lose sales and fall behind in repayments. Micro enterprises were worse off on both these measures by a margin of about 10 percentage points. The core premise of both documents is that there should be special rules in insolvency frameworks for MSMEs that make it easier for them in terms of cost and accessibility to access liquidation and restructuring. Another important recommendation is that the legal system should grant debt discharge to all good faith debtors who are natural person entrepreneurs following a liquidation proceeding. The pandemic, in which many businesses have been devastated through no fault of the entrepreneur, underscores the point that in circumstances where there is no prospect of repayment, there must be a pathway out of indebtedness for individual debtors and room for a fresh start. Another important recommendation is that the preferred approach is for the debtor to retain control of their business in the course of a reorganization. Again, this reflects the reality that, particularly in the case of a micro or sole entrepreneur business, the debtor could not operate, the business could not operate without the debtor in control. It's exciting to see the beginning of an upsurge in insolvency frameworks that reflect the needs of MSMEs, and I hope to see this continue. I want to thank you for taking the time to listen to me today and for inviting me to this wonderful event. I hope you enjoy the rest of the discussions and deliberations. Thank you.
Thank you. Although he can't hear us, thank you very much indeed. Well, we've got time for a few Q&A. I think we've got at least one question for each of the panelists. So we'll start in the room here in Hong Kong. Judge, the first one's for you, really. Hong Kong is the third largest financial center in the world. We've seen a boom in the number of Hong Kong IPOs, not only this year, but in recent history. And many of those listcos have all or most of their assets in the mainland. If a major insolvency of a Hong Kong listco with assets mainly in the mainland occurred, is the legal regime in Hong Kong sufficiently advanced to deal with that scenario?
Well, I think the answer is yes, the systems that we have in place in Hong Kong are adequate to deal with a liquidation in Hong Kong. The complication, if the assets are in the mainland, is how one manages that part of the process. Now, commonly, what we find is that a listed group will have creditors in Hong Kong and offshore, commonly holding Hong Kong dollar and US dollar denominated debt. And the group will have creditors onshore in the mainland. They may be trade creditors, they may be mainland banks who've lent to subsidiaries, there will be cross guarantees, that kind of thing. And in practice, the liquidation in the mainland is a liquidation of individual group members. So the liquidation process at the holding company level can be relatively straightforward. This is where the cooperation arrangement that was entered into on the 14th of May is engaged. It's the mechanism which allows us, where it's worthwhile doing so, to try and liaise between the two internal jurisdictions to maximize a fair distribution of the available assets for creditors both onshore and offshore. But the Hong Kong insolvency regime doesn't operate within the mainland, so there's a kind of there's an inherent contradiction in the question, I think.
Thank you. A question, I think, for you, Professor, in Thailand. You talked very well about the new legislation, and the simplified insolvency procedures targeted at MSMEs, so the micro, small and medium enterprises. Are any international organizations currently working on simplified insolvency procedures for MSMEs? Question one. Question two, is Thailand ahead of the game on this, or are other jurisdictions also dealing with simplified legislation for these MSMEs?
Thank you, Justin. In order to move for simplified mechanism, in fact, Thailand is part of the scheme that coordinated with international organizations. We receive advices and some other recommendations from various international organizations. The World Bank is one. We also, in fact, look through the work of UNCITRAL and trying to make sure that we get the whole of that. So basically, this is not what we actually move forward among ourselves. We receive other information from like South Korea and Japan with respect to their MSMEs work. So in a way, that is not quite unique, but we try to make sure that the system in Thailand is more simple, and something that perhaps we see as a moving forward is a DIP for the tier 2, and that if I can elaborate a little bit more on that, the reason for choosing the DIP for the small mechanism would be because of the cost and benefit. We encountered the situation of the fighting for the power to run the company during the insolvency, and it seems to be quite costly, and that wouldn't be perhaps suitable for small enterprises. We wouldn't see ourselves as we are ahead of the game. In fact, if I would say that with respect to the cross-border insolvency, we might even be behind many countries in Asia. But for the domestic context, I think we somehow still in the reasonable approach. We encountered the situation of the cross-border insolvency recently. The issues of the Thai Airways are still fresh, that the people were looking at the COMI in Thailand, but still there are so many firms believe that it might be somehow better dealt with in some other countries, but eventually the COMI context prevails. So I think we are quite reasonable, Justin.
I think very modest. Thank you, Professor, for that answer. Samira, I think a question for you. We'll see if we can get the technology to work. The question's just disappeared. That's ironic. I think the question, Samira, was, given all the work that Working Group 5 has done on insolvency, are there any learnings from that work for other areas of law? I think it's a very broad question, but see what you make of it.
I would say that as in any working group, the main learning is, of course, the will of states to enact what UNCITRAL prepares, because much resources and time is invested in preparing of uniform standards in the area of commercial law. Some in the form of a template like model laws for enactment at the national level, some in the form of international conventions, some are in soft form, legislative guide. But in the end, those texts would remain on the shelf if there is no will for states, different jurisdictions to use them. There might be will, but there might be no local capacity to use them. And of course, one of the main aspect of work of UNCITRAL in the area of international trade law is to increase such capacity through our cloud system, where we collect case law on our text, on UNCITRAL texts, and model on cross-border insolvency generated quite a lot of case law, and we are collecting and analyzing and systematizing this case law and preparing digest of case law, as well as judicial perspective and other tools for judges. And we also engaged in technical assistance activities with governments that are willing to use our texts, but may need to increase understanding of provisions in those texts, and also the increase also for capacity of policymakers to understand for core provisions of UNCITRAL text. That's really for all to be taken together. We in Working Group 5 do one part of work, which is legislative. But in order for that legislative work to produce tangible results on the ground, this work needs to translate into practical steps on the ground. And this is where our different directions of work become relevant, including regional center on Asia and Pacific work on technical assistance, and also our team in Vienna that deal with different steps that aim to bring those texts to end beneficiaries. Thank you.
Thank you, Samir. And very last question. We've heard a lot today about technology, in the courts, and we've heard about the fantastic initiative of IBRAM in Hong Kong. Does technology, or could technology play a more important role in the courts in relation to insolvency? Is there any specific insolvency angle to the use of technology? Probably a question for you first, Judge, and if we've time for the Professor.
Other than the obvious things that we're already tending to use increasingly, like digital bundles, digital filing systems, which we begin to introduce, not particularly, except if there's court-to-court communication. So you're trying to do things in between different jurisdictions and different time zones. But that gives rise to rather conventional issues: language, time zones, legal systems. So I think the answer is there's nothing special about insolvency really, which technology is going to assist. I'm quite interested in terms of using it for more data-driven analysis of what we're actually seeing, because I tend not to see much in the way of records of the kind of insolvencies that we're having to handle, small, medium-sized enterprises, those kind of distinctions.
And Professor, in terms of the new legislation in Thailand and the simplified regime, does technology play a role in the go-forward plan?
Oh, thank you, Justin. I think this is the right question. In fact, I must thank COVID-19 for this effect. We have to do away obstacles, especially in law, that prevent us from going electronically. The courts now adopt various approaches, including the hearing, even in criminal cases where they can do that through electronic means. In terms of the insolvency practitioner and the official receivers, we have to adopt the new process of electronic bidding, meeting, and in various aspects. So I would say that COVID-19 advantage is moving Thailand towards the more e-approach, and we have done that. So the law doesn't say anything about it much, because it has been done through other legislation. Thank you.
Well, that brings us to the end of the final session for today. And I think whichever way the global markets go, I think it's fair to say we're clearly in very safe hands with the experts that you've heard from today. So please join me in thanking them and go well. Thank you very much.
Thank you very much. Please stay for a quick virtual photo. So to our speakers online, please look at your own camera. And to our moderator and speaker on stage, please look at our camera at the back. So 3, 2, 1, smile. All right, wonderful. So let's put our hands together once again for our moderator and all of our speakers. Thank you very much. So to conclude today's conference, we would like to invite Ms. Athita Kaminda, head of the UNCITRAL Regional Center for Asia and the Pacific, to deliver a closing remark. Ms. Kaminda, please.
Thank you very much. The Honorable Teresa Chang, Secretary for Justice, the Honorable Chief Justice Andrew Chung of the Court of Final Appeal, distinguished speakers and honored guests, greetings from the UNCITRAL Regional Center for Asia and the Pacific, or UNCITRAL RCAP, in Incheon, Republic of Korea. It is my honor to deliver this short closing. The successful first day of the 4th UNCITRAL Asia-Pacific Judicial Summit bodes well indeed for an auspicious 2021 Hong Kong Legal Week, which I regret not being able to personally join. Thank you again to our co-hosts for the smooth organization despite the challenging circumstances. And like Madam Secretary, I acknowledge with thanks the collaboration with the Asian Development Bank to include interpretation for our Armenian colleagues. UNCITRAL Secretariat is delighted to expand outreach to include so many stakeholders from landlocked jurisdictions and looks forward to continuing our partnership for future activities. Next slide, please. As mentioned by the Secretary of UNCITRAL, Ms. Anna Jubin-Brett, this morning, the need for modernization of international trade law via UNCITRAL text and legal harmonization are particularly compelling for sustainably adapting to a new normal. When such modernization does not occur or occurs in a disharmonized way, international trade suffers. This has long been recognized by states. When world trade began to expand dramatically in the 1960s, states began to realize the need for a global set of standards and rules to harmonize and modernize the assortment of national and regional regulations, which until then largely governed international trade. They turned to the United Nations, thus leading to the General Assembly establishing UNCITRAL in 1966. And UNCITRAL has since then become the core legal body of the United Nations system in the field of international trade law. Next slide, please. The mandate of UNCITRAL to promote the progressive harmonization and modernization of international trade law was designed to address concerns that conflicts and divergences arising from the laws of different states in matters relating to international trade constitute an obstacle to the development of world trade. The intellectual discussions that we heard today on access to credit, digital economy, dispute resolution, and insolvency and restructuring are all ongoing projects of UNCITRAL's core work, legal harmonization. Texts developed by UNCITRAL aim to remove trade barriers, reduce transaction costs, and provide legal certainty and predictability, which in turn promotes the doing of business, investment, and cross-border trade. UNCITRAL's widely accepted instruments have bridged the gap between the civil and common law, offering solutions appropriate to different legal traditions and to countries at different stages of economic development. Further, UNCITRAL texts take different forms, such as conventions, model laws, and legislative guides, which are flexible enough to cater for different subject matters and changing environments. Next slide, please. My office, the UNCITRAL Regional Center for Asia and the Pacific, is UNCITRAL's only regional center and opened our doors in Incheon, Republic of Korea in 2012. Supported by the South Korean government and also Hong Kong SAR China, including via secondees from the Korean Ministry of Justice and Hong Kong SAR Department of Justice, the Regional Center carries out UNCITRAL's mandate in approximately 60 jurisdictions in the Asia-Pacific region, working with government officials, the judiciary, legal and business experts, and academia to further the progressive harmonization and modernization of international trade and commercial law by promoting the use, adoption, and uniform interpretation of UNCITRAL texts and providing capacity building in this regard. The Judicial Conference today and the Judicial Roundtable tomorrow for judges and judicial personnel are excellent examples of such work. This year marks the 10th anniversary of UNCITRAL RCAP, and the Secretariat is very proud that since RCAP's establishment, the majority of Asia-Pacific jurisdictions have adopted at least one UNCITRAL instrument, greatly contributing to legal harmonization to facilitate regional and global trade and investment. Through RCAP, UNCITRAL has expanded its regional accessibility by delivering with its partners outreach activities in multiple United Nations and regional languages, including Chinese, English, Russian, Cantonese, Korean, Thai, and Vietnamese. Next slide, please. For participants interested in learning more about UNCITRAL, I invite you to join the Regional Center's virtual events throughout the region, especially our flagship events as shown. Next slide, please. For academics in the audience, I draw your attention to the UNCITRAL Asia Pacific Day flagship series. This is an annual series of academic activities that UNCITRAL RCAP co-hosts with institutions of higher learning on a wide range of UNCITRAL thematic issues to raise awareness of the international commercial legal landscape and UNCITRAL to law students and other stakeholders. Last year, RCAP co-organized a total of 19 UNCITRAL Asia Pacific Day events with 35 partnering institutions in 10 jurisdictions, including China. This year's AP Day theme is enabling micro, small, and medium-sized enterprises and assisting economic recovery through legal harmonization. And we invite universities in the audience to join these celebrations by visiting the UNCITRAL webpage or reaching out to UNCITRAL RCAP at uncitral.rcap@un.org. I proudly note that for this year, an initial 34 universities and institutions across the Asia-Pacific region in 13 jurisdictions will co-host at least 20 activities with the Regional Center, which we expect would highlight the importance of MSMEs to the global economy, to several thousand law students and regional stakeholders. Next slide, please. Last, but definitely not least, I invite all of you to take UNCITRAL's first online training course, Introduction to the United Nations Commission on International Trade Law, which was launched on 12 July 2021. Could you go back to the previous slide? Thanks. Developed in collaboration with the International Training Center of the International Labour Organization, this interactive and self-paced course introduces users to legal harmonization, UNCITRAL's methods of work, and how UNCITRAL texts contribute to the achievement of the Sustainable Development Goals. Currently available in English and very soon in Chinese, the 3 modules are the first of a forthcoming series. The course is available free of charge on the UNCITRAL website, and users will be able to enroll in the course upon creating an account. An electronic certificate is downloadable from the platform for users who complete all 3 modules. Last slide, please. UNCITRAL RCAP invites you to peruse our webpage and subscribe to our mailing list via the QR code shown there. On behalf of UNCITRAL, I would like to express our heartfelt thanks to the Department of Justice of Hong Kong SAR China and its diligent counsel for co-organizing this meaningful conference with great effort. I wish the Hong Kong Legal Week 2021 every success and sincerely hope we will be able to meet in person at the next Judicial Summit in 2023. Until then, I wish everyone good health and a good evening. Thank you.
Thank you, Ms. Kaminda. So ladies and gentlemen, the 4th UNCITRAL Asia Pacific Judicial Summit 2021 Day 1 has come to an end. On behalf of UNCITRAL and the Department of Justice of the Hong Kong SAR of the People's Republic of China, we would like to take this opportunity to thank all of our wonderful speakers and moderators, and thank you for attending the Judicial Summit and for making this event a success. We would also like to express our gratitude to our supporting organizer, the Asian Academy of International Law, and the supporting organizers of Hong Kong Legal Week 2021, Invest Hong Kong. We hope that the presentations and discussions have been of great value to you. So ladies and gentlemen, before you leave today, please remember to return your headsets to the help desk at the entrance and kindly scan the QR code on your table to fill out a questionnaire for us. So once again, thank you very much for joining us today. Goodbye.